Good morning, everyone. Welcome to the Judicial Proceedings Committee. Today is Friday, February 2nd, 2024. We have 8 bills on the docket. We're going to start off with Senator West, 319. We're starting a little bit light here with attendance, but we've got 64 witnesses and 8 bills, and it's Friday. So, Senator West, you're up.
Chair, I said goodbye to you last night. I'm saying hello to you this morning.
I spent more time with you in the last 48 hours than I've spent with my wife. So
really, we have to stop living like this. It's a pleasure to be here to introduce Senate Bill 319, which is an exceedingly simple bill. Last year, the General Assembly passed House Bill 824, another simple bill, which in relevant part tasked the State Commission on Criminal Sentencing Policy with collecting, compiling, and making annual reports relating to regulated firearms violations. Along with Delegate Bartlett, I'm a member of the Criminal Sentencing Policy. At one of our meetings last summer, the executive director of the commission, David Soleil, gave us a report about House Bill 824. The gist of his message was that the commission did not have access to the information demanded in House Bill 824, and that would have to hire staff to visit other state agencies to collect the information. He suggested that the Maryland State Police probably has the information readily available. So Delegate Bartlett and I stated that we could just amend the law to reassign the responsibility for collecting and reporting the information. As drafted, therefore, Senate Bill 319 simply transfers that responsibility to the Department of State Police. Last week, however, I had 2 groups visit my office. First, the state police came by and told me they didn't have the information either. And then Chief Judge Morrissey of the District Court of Maryland came to see me and told me that the judiciary has the information right at hand and could easily collect, compile, and report it in accordance with House Bill 824. So you will find an amendment at your desks altering Senate Bill 319 to assign the reporting responsibility to the Maryland judiciary. I'm enormously grateful to Judge Morrissey for taking the initiative and coming to see me. Otherwise, I would have gone on a treasure hunt through the state bureaucracy to find which organization had the information. Clearly, it's the state judiciary. I appreciate your consideration of Senate Bill 319. I think Judge Morrissey is here to briefly echo what I just said. Thank you.
Chairman Smith, the Vice Chair Wallstriker, members of the committee, good morning, everyone. And I know you were all here late. So Senator West said it all. We just saw this. We typically, whenever we look at bills like this, we ask our IT department to do a level of effort to see how hard it would be to fulfill this. It was a small level of effort, so we recognize that we don't want a whack-a-mole situation going on, and we'd be happy to do it. So I watched, Senator, last night, some of the testimony, and I know that it was critical of the judiciary and some of what we put in our fiscal notes. And I hope this goes some way to show you that we are earnest in our approach to this committee in the responsibility we have with our fiscal notes, and that we do it with good reason. And where we can, we will step up and take the initiative. So I appreciate this committee listening, and thank you all. And I forgot last time I was here to introduce our new state court administrator, Miss Judy Rue. Judy, would you like to, if you don't mind, Senator?
I just want to introduce myself. I was the court administrator in Montgomery County following Pam Harris there. I've been fortunate to be able to be asked to be the state court administrator to follow Pam in her role leading the administrative office of the courts for the judiciary. So I just wanted to introduce myself and thank you for your time.
No, we enjoyed meeting you in the interim when we took our trip down, so we really enjoyed that. So welcome.
And with that, I rest my case and I'm willing to take questions.
Questions for me? Thank you both very much, and for the chief, thank you for the comments. I think we had a good discussion last night, and we're looking forward to working with you.
I'm kind of like House of Cards. I'm going to create a show for Netflix that's called The House or The Body, because it was riveting last night. And you had great comments to try to calm everybody. That it's really an interesting process that we go through.
Yep.
the sentiments resonated with me, so.
Well, I appreciate it. Thank you very much. It's good to see you all. All right. Well, with that, it's good to know someone's watching, you know. That's probably not such a good thing. I don't know. That concludes the hearing for Senate Bill 319. We'll now move on to Senator McCray, who just walked in with Senate Bill I'm sorry, my apologies. We're going to take Senator Salling first, Senate Bill 355. Thank you for the reminder. Senator Salling, welcome. You're up.
Thank you, sir. Thank you, senators. Thank you, Mr. Chairman and Vice Chair and committee. You have my testimony and I'm going to be brief and just let you know that for the record, I'm Senator John R. Salling. Thank you, Chair, Vice Chair and Committee of the Judiciary. In current law, there is a definition of items and related to a prohibition of display and disturbing obscene materials to minors. Just to be brief, in our schools, we have material that I think is very inappropriate for our young people. Photographic material can be very disturbing for our young people in our schools. And just knowing that explicit sexual material and things that are out there are just so disturbing that our young people should be seeing that type of material in our schools and our libraries. And just knowing that photographic things that are presented to us are pictured in a way in our mind that can stay there and stick there for a long period of times and sometimes for life. And just knowing that it's disturbing to know that that kind of content is out there for our young kids in our elementary schools and our middle schools. And we want to make sure that these type of things aren't out there and that our photos are not sentences that could be disturbing for our young kids. And we've said many a times that even our young people and at the age of 20 or 25, these types of things are out there. That adults, that's different, but minors, it's just driving certain things that I believe that are very disturbing. We have parents and parents need to be the ones that if they want to talk about certain issues, they are there for the kids, but not in our libraries. And Mr. Chairman, you know, just to say this, if we want to teach our kids mathematics and teach our kids certain things of science, that's important. And that's why our kids are being educated in our schools and we have things in our libraries. But it's disturbing to have pornographic things, photos that are in our libraries, in our areas of our schools for our minors. And Mr. Chairman, I just want to say this, Mr. Vice Chair and committee, I want you to really know this more than anything, and I hope you are listening to me. You have bills, and if you have bills that are presented, and if somebody that is against your bill, I hope they give you the avenue that you have a conversation with them and talk with them. And I want to let you know, there were people that are against this bill that didn't even come to me. They didn't even talk to me. My door is open to them. And your door is open to them. And if they want an amendment or something, they should come to you and they should talk to you. But they haven't came to me. So I want to let you know, my door is still open for them. And my door has always been open. And if you're against my bill, I'm happy to sit down you with a cup of coffee and talk to you about it. And I want to thank you for moving my bill up because you know I have my subcommittee is going to be coming. But I'm still here today, standing here saying, if you're against this bill, come to me and talk to me about it. Thank you, Mr. Chairman. And I'm open for any questions.
Well, thank you very much, Senator. Seems no questions from the committee. We'll move on with the rest of the panel.
Thank you.
Excellent. Thank you. Is John Palmer here? Come on up. Welcome.
Good morning. I want to thank you for the opportunity to speak this morning. My name is John Palmer. I'm from Wicomico County, and I am a member of the Wicomico County School Board. If you would like to sit in on a committee sometime or a meeting, you should come to some of our school board meetings. I guarantee you, you will take note of what is going on. And it's very important. This bill I'm in support of, and I hope it goes through, and I hope other bills like it go through. I do have a very short statement. what is happening with the obscene materials in our schools and classrooms and the media centers. This is not new. COVID just brought it out into the open, and now parents can see what's going on. Why is it happening? If you want to change society, one of the best ways to do it is to change the morals. When you change the morals of the young children, you change the morals that are coming from these obscene materials into obscene morals, and it breaks down our society. Now, I sent out some information on what you see in school. I was kind of embarrassed to give it to the ladies next door who they actually helped a whole lot, but they put it into the system so you can read it. Some of it is really embarrassing. I had it in a folder and I put a big X on it because I really didn't want to see any of your pages to see it. But that is actual material that's coming out of our classrooms right now. You can go down to our schools and you can find this material in there. We have kind of a backup plan on the board to help. We have worked a lot on it. But I hope your bill goes through and I hope you support it. Thank you.
All right, thank you very much, Mr. Palmer. Questions? We have, Mr. Palmer, I'm sorry, we have a question. Senator Sidnor has a question for you.
Yes, sir.
Thank you very much. I'm curious, within your school system, do you have schools that focus on the arts?
Excuse me, could you speak up?
Do
Just
you have any schools that deal with the arts?
that deals with the arts?
Right.
Oh, the arts. Oh, I'm a fan of the arts.
So let me, I'm just curious, how would this legislation affect those schools who with art classes? Because I have two daughters who attend a public school in Baltimore County that is a visual arts school.
Okay.
And they have classes, and I know I've seen artwork with students who have drawn nude figures. So how would this legislation affect the ability for those schools to have those art classes?
All we have to do is follow the law. The Supreme Court has a litmus test for what they call obscene material. It's called the Miller's Law.
Right. So
It has three.
what is obscene that you might not be obscene to me, right?
Right. And
So what I'm asking, so I just want to be clear how this bill would affect those kinds of classes where you're trying to teach students how to draw the human body.
if it's deemed obscene by law, then it will not be taught. And I know that there's a question between what is art, it's like between what is a good book and what is a bad book.
Yes.
Like what we want to do is if it's a book is obscene, we're going to take it out of the school. However, if it's questionable, we want to put it in a place where it has to be checked out by the parent or with a permission slip from the parents. And the arts is one area where we still have to make those decisions on. And you're right.
And that's one of my main concerns about the legislation, because again, what may be obscene to one may be art to another, and it's a difficult. It's even the Supreme Court hasn't. You can't draw a bright line when it comes to this kind of stuff because it's opinionated, right? It's subjective.
Yeah, it is subjective, but I believe the Miller's Law is objective. I mean, it gives you the points, and the points are very clear. 2 of the points are based on community standards, and one of them is based on the reasonable person law that they use. And I think if you apply that, then you will get through the part on the art. We haven't got to the art yet, but we're going to.
But thank you very much.
And I appreciate you all voting for this. Thank you.
Thank you.
Yes,
Sir, Mr. Palmer, our apologies. We have
For
still on the
either-
hot seat. We have a couple
for
questions.
either,
Yeah.
thank you,
Sorry.
Mr. Chairman, for either the gentleman or the bill sponsor. I am aware of the debate, it's going on around the country, and so what I'm troubling with is just how this bill is drafted. So it seems to me, but you can tell me if I'm wrong or show me later after the hearing, but it already says that there's control over obscene pictures. And I feel like a picture would encompass a drawing or illustration. It just says still picture or photograph. So we know we're not dealing with photographs. So I'm not sure why we need drawing or illustration, as I think still picture, unless you have an attorney general's opinion or legal opinion that says that those two words are not encompassing drawing and illustration. I don't see that we don't already have the capacity and ability to deal with this under current law. So just what I would suggest, Senator, is maybe go back and look into that question of whether still picture or picture is broad enough to encompass drawing or illustration. I can tell you, if you look in an ordinary dictionary, it would encompass it, but maybe there is somewhere else in statute some difference in which this language is needed. So I just throw that out, for you to look at later.
Sure, Senator, and I appreciate that. The definition of item is related to a prohibition or display or disturbing obscene material to minors. That's what that definition is that's how it's defined.
Mhm.
So, but I would be more than happy to get the Attorney General's opinion. But I think at the same time, we're stating the facts that there's certain things that are out there that are not just obscene, but are just plain wrong to a parent's opinion at the same time. And we would like to have the opportunity for that parent to be a part of this conversation, because a lot of times the parents are not. And I think that's disturbing with any constituents. If you have a parent that's upset about something, I believe at any given time, they should have the opportunity for a conversation about their children.
I couldn't agree with you
Yes.
more, and I
I'm
don't,
scared.
I couldn't agree with you more.
Yeah.
So that I totally agree with, but I think that this is a very specific question. It's important. And I will tell you another reason it's important. Throughout our statutes, we have words like picture. And if suddenly the word picture would not encompass drawing or illustration, then we would have to go look at this throughout the code. So I think it's very important that when we draft a statute, we're very, very precise and clear.
And I
So-
think it should be.
You know what I mean? So thank you,
Yep.
and find out. Would
Sure.
you please? Thank you.
Senator, did you see the pictures that was in that packet that was sent?
I have the photos of them.
Yeah, those are pictures. And I'm really
makes
surprised
my
that some
point.
parents haven't filed an injunction to stop what's going on in our schools with this material. Because clearly it passes the Miller's test. And in fact, that might come up. It just might come up.
Well, I think with the law that they have federally, if I could, Mr. Chair, the law they have federally, and with the Attorney General's opinion, we could get a little bit more details of that if we wanted to do something like that, as the Senator stated. So, yes, sir. Thank you. Thank you, Mr. Chair.
All right, thank you very much. All right, that'll conclude the testimony for the proponents of the bill. We'll now hear from the opponents. We'll hear from, is Emily Pule here? Yes, come on up, and then we'll be joined virtually by Mr. Zacher.
Thank you. SB 355 purports to protect minors from obscene materials, but what it really does is hand a blunt instrument to the inorganic groups proliferating today, groups that under the guise of freedom are pushing a book banning agenda that targets viewpoints and communities they don't like, in particular, LGBTQ+ youth. The end result of this bill will be that these anti-LGBTQ+ groups will enter school libraries and with faux outrage claim that books with LGBTQ characters and themes contain obscene descriptions of illicit sex. They'll completely ignore the prong of the definition of obscene that says the work as a whole must lack serious artistic value, because their goal will not be to engage in good faith evaluation of materials that minors have access to, but instead to attack and to delegitimize the LGBTQ+ community, to diminish its voices, and to wipe away its stories. By adding public schools to this section of the Maryland Criminal Code, this bill will open the floodgates. It will have a chilling effect, which we can presume is precisely the point. School principals fearing criminal liability will likely choose to preemptively remove and then to avoid LGBTQ plus books rather than invite endless chaos, distraction, litigation, and prosecution. This will leave LGBTQ plus students without representation in literature, without access to stories that offer them validation and acceptance and love. Our youth deserve better. I urge you to reject this unnecessary and unkind bill. Thank you for your time.
Thank you very much. Thank you for joining us. We have one question from Senator McKay.
Thank you, Mr. Chair. Ma'am, do you have any evidence of that?
Evidence, I think we see.
You've made some comments. I just didn't know if you had examples of that.
In Florida, many books have been pulled off shelves, sometimes
So in Maryland, you don't.
uh,
Did you discuss this with the sponsor?
I did not.
May I suggest you might want to talk to him to find out exactly where he's putting this in and not from hearsay from Florida. So thank you.
Thank you very much. Thank you for being here. All right, Mr. Zacher, you're up.
Thank you and good morning to the committee. My name is Jeremy Zacher. I'm an assistant public defender here in Baltimore City. And the Office of the Public Defender asked this committee for an unfavorable report on Senate Bill 355. We are concerned about this bill being used to promote censorship, and it could create a chilling effect on school officials and particularly school principals. Whenever we create a new criminal statute or expand an existing criminal statute, we are inviting members of the public to file criminal complaints. SB 355 sits in a space that is uniquely politicized, where a tiny fraction of our population seeks to restrict access to books and material based solely on their own moral viewpoint. And we've seen how laws in other states that address allegedly obscene materials in schools have been used to ban material. In Florida, for example, a school banned the dictionary for fear it may run afoul of obscenity laws. And in Utah, a school district banned the Bible. Many books for children are illustrated, and books that touch on issues of sex and sexuality have been targeted by activist groups across the country. Books addressing the LGBTQ community are particularly targeted for this sort of censorship. And this censorship seemingly has no end because it's based on a fairly subjective standard of what is obscene. Expanding a statewide criminal statute is not the answer. Should a citizen of Maryland have a concern about a particular publication within a school library, they can talk to their local school principal, local school board, or local parent-teacher association, or even have a conversation with their child about what is appropriate reading. The Office of the Public Defender is asking for an unfavorable report on Senate Bill 355. Thank you. That's all I have.
Excellent. Thank you very much, Mr. Zacher, for joining us. We have one question from Senator West.
Thank you. For the public defender, if I could, are you familiar with section 11-2 or 3 of the criminal law article?
I'm not off the top of my head, but if you, the one that's being amended, the one that's being amended by the bill.
That's the section being amended here. Well, that
yes, I have it in front of me.
Great, perfect. Okay, it has a definition of obscene. It's section subpart 5, 1A5.
Yes.
So as I read that definition, it appears to me to be the Supreme Court's definition of obscene. Do you agree with that?
Yes, it does appear to be that.
Okay. And then subpart B says a person may not willfully or knowingly display or exhibit to a minor an item, one, the cover of or content of which is principally made up of an obscene description or depiction of illicit sex, or two, that consists of an obscene picture of a nude or partially nude figure. That's current law. Do you disagree with current law in Maryland?
We're not taking a position on the current law. We're taking a position on the expansion of this current law.
Okay, well, the current law doesn't seem to limit its applicability to any particular location. By my reading, it's universally applicable and would include schools. So do you think that the current law should be repealed because it does apply to schools?
We're not taking a position on whether or not the current law should be repealed. This particular bill is specifically expanding the law to public schools and specifically mentions school principals.
So
as
do you
the
believe the
responsible
current law
party.
does not cover public schools?
I'm not taking a position, the Office of the Public Defender is not taking a position on what the current law covers.
But you're
We're
saying this bill expands the law to include public schools. It's my contention the current law already includes public schools. Do you disagree with that?
We're not taking a position on whether it currently includes public schools, but if you feel like it already includes public schools, then there is no need for this law, this bill.
Thank you.
Okay. All right, seeing no further questions, thank you very much. With that, that'll conclude the hearing for Senate Bill 355. We'll now move on to Senator McCray with Senate Bill 324. Senator McCray, welcome back.
Thank you, Mr. Chair. For the record, Corey McCray, Senator for the 45th Legislative District, and I've spent a significant amount of time, more time before JPR than I usually do. This bill, Senate Bill 324, is a product of meetings that I have with my majors, my colonels, my lieutenant colonels, on a periodic basis every couple of weeks to be able to understand the non-fatal shootings and the shootings within my respective district. And one of the things that I've understood during those meetings was that there was an uptick in the accidental shootings that was actually taking place. I recognize that majority of the people do have unregistered firearms, and I believe that there are laws on the books to be able to deal with that. But one of the upticks also happened with those that are registered firearm holders. And when recognizing that, I asked the question, when a person does have an accidental discharge, whether it's property or if they shoot themselves, what happens next? And I asked the question, do they get more training? Do they get a better understanding? I think that when firearm training is given, Mr. Chair, the first things that you recognize is you keep you point the gun at a different direction, make sure that it's not pointing towards you, but you also make sure that it's not chambered. You make sure that you keep the finger off the trigger. And these are basic fundamentals that they keep reiterating and reiterating and reiterating, and something must have went wrong during that situation. I'm going to bring up something that was more recent that really grabbed my attention. So we have a complex, apartment complex in my district, Dutch Village. It's up there off of Northern Parkway. And one of the accidental discharges had actually taken place in this apartment complex. And I was thinking in that standpoint, when you're in a rural jurisdiction, if you shoot somewhere and you have an accidental discharge, it hits the wall, but it may not impede or impact something else. But when you're in dense populations like that and you have an accidental discharge, there are possibly strong consequences to be paid from that standpoint. I'm not asking for folks to have their guns and things of that nature removed out of their home, but I do ask that when we do have accidental discharges, that the requirement of the firearms training that did took place at some point in time during them acquiring that respective license, that is taken over 4 hours from that standpoint. We would ask that 4 hours, and I was able to consult with some of the folks that are engaged in this, that 4 hours, at least you register for the class within 90 days, because they may shoot themselves, but they may still be in the hospital. So we want to recognize that piece of it. So they have to register for the class within 90 days, but they have to take the class within 120 days. And I think that this is a good middle of the road solution when we do have those accidental discharges, that folks go back in and get that training again. This is specifically identified for wear and carry permits. I'm sure that you all will recognize that there's been a significant uptick within the wear and carry permits. It looked like we were about 30,000 previously, about a year ago, and now we're over 100,000 people having their wear and carry across the state of Maryland at this moment from that time. So I look at this as a good middle of the road bill to be able to address something that I see in the uptick of accidental discharges.
Thank you very much, Senator. Do you want to bring up your proponent and then take questions at the end of that, or?
Yes,
All
yes,
right.
sir.
Well, we hear from Ms. Tholimis. How are you?
Good morning, Chair Smith, Vice Chair Waldstraker, and members of the committee. My name is Nina Themlis. I serve as Director of the Mayor's Office of Government Relations. I'm here to testify on behalf of the Baltimore City Administration in support of Senate Bill 324. The common sense requirements outlined in this bill are vital to help prevent unintentional discharges and the potential fatal consequences related to such incidents. This legislation is in alignment with the Scott administration's broader support for gun ownership practices that protect our residents without infringing upon the rights of Marylanders to possess firearms, as long as they do so responsibly. By requiring handgun permit holders to complete a certified firearm safety training course following an accidental discharge, the bill enhances Maryland firearm safety laws without ending or eroding individuals' rights to bear arms. According to the U.S. Centers for Disease Control and Prevention, approximately 45,000 people die from firearms injuries every year. About 1% of those are estimated to be attributable to accidental discharge, which equates to more than one person per day. This bill will help prevent future loss of life and encourage Marylanders to practice safe operation and responsible gun ownership practices. For these reasons, the Baltimore City Administration would like to thank Senator McCray for bringing forth this piece of legislation and urges a favorable report for Senate Bill 324. Thank you.
All right, thank you both. We'll have questions from Senator McKay and then Senator West.
Thank you, Senator, for bringing this bill. You had made a comment that, if I heard you right, correct me if I'm wrong, sir.
Yes, sir.
Registered owners are not necessary, that registered owners are permit holders. And I just want to clarify that just because you're a registered owner of a firearm, it doesn't mean that you're necessarily a permit holder, because you don't have a carry conceal.
You're absolutely right. You have, for those that may not know the distinction, you have a HQL and then you have wear and carry permit.
Right.
Yeah.
So, okay. I just wanted to clear. Second of all, look, I think education is the key to gun control and gun laws. Education. Did I mention education? So I'm just wondering, would you be interested in maybe an amendment that said something about, right now there's classes that are like only 3 days worth of education, maybe going to a 5-day education component. And I just don't know if you'd be up to discussing that with me.
I would be open. I think that the 4 hours will get you done in a 1 day. I think that there looked like some of the, there was some unfavorables. I'm not sure why they would be unfavorable to 4 hours, but I don't know how they would feel. I wouldn't have an issue with that piece of it, but I do want to make sure we run the risk.
One of the concerns that I have is that, look, we do have an uptick. I think it's because people want to exercise their constitutional right. I tend to believe that that's the way we should be going. But I also believe that I don't want people just dropping in from other states, having a 3-day class, give somebody a permit, and I don't believe that they've been actually gone through the educational part. So that's, I'm just trying to possibly talk to you about amendment for strengthening the education of it.
Okay, no problem at all. Just know that this one was worked through with the state police. So like they spent a significant amount of time helping me guide and understand what was necessary for this to be successful.
Well, I understand. Thank you very much.
I did omit, Mr. Chair, that I do have an amendment. So when getting my cross file for the House bill, that she referenced a good point, that just basically the amendment would say include information describing the certified firearm safety training course required under subsection B of this section. And that just recognizes that they don't have to find it out by themselves. They will get some level of notification that they do have to take this course if they shot themselves.
Okay. Thank you. Thank you, Mr. Chair.
Chair, good to see you here in our committee, Senator McCray. So I guess my first question is, your bill only applies to people who hold carry permits.
Mm-hmm.
There are lots of people who own guns legally in Maryland who don't hold carry permits, aren't there?
I think that you all know better than I do in reference to how contentious the moment that we stand in around gun ownership is and the case law that's coming about. I think that I didn't include HQL because right around when I was drafting the bill, there was some rulings that came down that did not come for wear and carry permits, and recognizing that, seeing that uptick, I don't quote me on this, but I want to say it's about 170. So going from 30,000 per wear and carry permits to like 170, that's a lot of people on the streets with a wear and carry permit in a short amount of time.
But there's still a lot of people in Maryland who own guns who did not go through the procedure to obtain carry permit. correct?
That is very true. But what I'm also trying to do is make sure that the bill is constitutional, be able to pass the constitutional space. I'm not saying that it wouldn't with the HQL piece of it, but I know it would. There's a higher probability just looking at the wear and carry permits.
So my understanding, reading your bill, is that if I don't have I've got a gun, but I don't have a carry permit and I accidentally discharge the gun, I don't have to take the course.
That is true.
Only somebody has a permit would have to take the course. So why wouldn't your bill apply to both people who don't have permits as well as people who do have permits?
First, for folks that may not know, and you do have a listening audience, like there's a greater responsibility with a person to have a wear and carry because they can carry in a significant amount of places that a person that just has a regular HQL from that standpoint. You all spend more time studying this subject than I do. I was just with my colonels, my majors, my lieutenant colonels, being able to understand and seeing the uptick within the accidental discharges. Because of everything that's going on from a constitutional space, I'm gonna repeat myself too, that there's a higher probability that this is still constitutional, and I'm not sure. You're a lawyer, I'm not a lawyer. What was the constitutional piece with the HQL?
Well, I really admire you're interested in observing the Constitution. In my view, that's very important.
My view too.
Exactly. So, well, let me ask another line of questions, and that is, I'm looking at the instruction that's required. Now, I'm not a gun owner myself, so I've never registered a firearm, but my understanding is that you have to take a course in order to do it.
Yeah.
So I'm looking at what your classroom instruction consists of. It's 4 hours of instruction on proper operation, safe handling, cleaning and maintenance, loading and unloading of ammunition, things like that. Isn't that already covered in the course that someone has to take in order to get registered as a gun owner?
That is absolutely correct. That there is already a requirement put in place if you are to obtain your HQL and if you have to get your wear and carry. For HQL, I believe it's every 10 years that you have to do something. For wear and carry, it's, I believe, every 2 years from that standpoint. But what I'm trying to recognize, Senator West, is that something went wrong between the time that that class was put on and when that accidental discharge take place. I talked about some of the fundamentals that you do learn in any type of gun training or firearm training class. You learn to point the gun in a different direction than yourself. You learn to make sure that the gun isn't chambered. You also make sure to keep your finger off of the trigger from that standpoint. Something went wrong, at least 2 out of those 3 fundamentals, when that accidental discharge did take place.
Okay, final question. Is there anything that's in your bill in terms of the required education that is not currently provided in the course that anyone takes who wants to has a gun?
Well, you would see within the language that it says is dependent on the colonel for the state police. So the state police will kind of make that piece of it. I'm not the subject matter expert. You guys see this a lot more than I do, but the state police will be able to set what does that training look like and things of that nature. And it can be duplicative. It's broad enough the way it could be duplicative, but I will repeat once again, something went wrong when that accidental discharge took place, possibly hurting themselves or hurting someone else's property.
Okay, thanks.
All right, seeing no further questions, thank you very much.
I appreciate it.
Thanks a lot. So that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. And if Ms. Wright, Mr. Jocelyn, Ms. Mooney, and is Mr. Penick here? And then we'll be joined virtually by Mr. Mohammed.
Thank you, Mr. Chair. My name is Kathy Wright, and I'm the Vice President of Legislative Affairs for the Maryland State Rifle and Pistol Association. The association opposes Senate Bill 324. Injury and death from accidental discharges are tragic. Some accidents probably happen to decent gun owners who make a mistake. The association is dedicated to promoting marksmanship and safe firearm handling through our affiliated clubs, statewide programs, and the NRA's Education and Training Division programs, and supports the state's efforts to that end. Thank you. However, Other accidental discharges occur when criminals are committing crimes. These individuals will surely not self-report their accidents, and this bill will not prevent violent crime. The bill is probably unconstitutional, as the Fifth Amendment protects against self-incrimination. The Maryland State Rifle and Pistol Association respectfully requests an unfavorable report. Thank you.
Good morning. Thank you, Chair and Vice Chair, for seeing us today. My name is Carla Mooney. I'm from Southern Maryland, St. Mary's County, District 29C. I am the State Director for Women for Gun Rights. I am also the State Leader for Armed Women of America. I kind of represent groups of women who support the ability to keep and bear their firearms for self-defense and personal protection. And I'm also a firearms instructor professionally. I've been teaching the concealed carry classes since 2015, 2016. As a firearms instructor, I do focus on those safety rules, but I do see and hear on a regular basis of others who maybe aren't as good at that because their background is military or police, and so that's what their qualification is. They get kind of lost in the minutia of, I want to teach gun stuff. So anyway, the most important thing here is I do feel completely responsible for every student I teach. And I feel that you're giving an additional burden to someone who should have had 16 hours of training if it is only for concealed carry holders. But even to purchase a firearm, they've had these 4 hours already. So I just feel like this is a burden, and unfortunate that mandatory training is probably the cause. I want to request an unfavorable report on this bill, mostly because I feel like we're already training. This is already happening. And I'd rather people weren't mandated to take classes, but took classes because being a responsible gun owner is what's most important in their lives. And I appreciate your time today. And
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. John Jocelyn speaking for 2A Maryland in opposition to Senate Bill 324. Under this bill, a permit holder who has an accidental discharge must register for a training course within 90 days. He must complete that training course within 6 months. The accidental discharge doesn't have to involve a handgun. Under the terms of the bill, it's any firearm, which includes rifles, pistols, shotguns, even unfinished frames and receivers, and starter pistols. If the person fails to complete this training within 6 months, the secretary is required to revoke their permit. Now, here's the flaws. If the person doesn't have a permit, it doesn't apply. If you're a prohibited person, it doesn't apply. If you're a law enforcement officer who does not have a Maryland carry permit, it doesn't apply. If you are a law enforcement officer with a LEOSA permit, it doesn't apply. There's no requirement that the person who has the incident report it to anyone. There's no requirement that the instructor report to anyone. There's no mechanism whereby the person would report to law enforcement. Law enforcement has a spotty history of reporting information, and this is noted in the AG study that they had trouble finding information on a bill that we passed several years ago. Therefore, the secretary is unlikely to receive any information whatsoever to enforce the bill. At the present time, we have 175,632 carry permits active. Have you heard of a single accidental discharge by a permit holder? Presuming we had this information and we're willing to invest $500,000, what will we do with the information? We do not believe this bill is worthy of consideration, and we ask for an unfavorable report. Willing to answer any questions you might have. Thank you.
thank you very much, Senator West. Sorry, my apologies. Mr. Mohammed, we'll go first and then we'll take questions at the end. Welcome.
Thank you, sir. I'm not used to being first.
Galen Muhammad, State Director for the National African American Gun Association, and we're in opposition to this particular bill. While the accidental discharge may be the result of carelessness or overconfidence, mandating training for that person is more or less of a harassment. They already know better. They've already gone through our training, as the instructors before me said. Not just the 4 hours with the HQL, but the 16 hours with the wear and carry or the concealed carry. One of the basic principles of firearm safety is to keep one's finger off the trigger, obviously, until one is on target and about to fire their firearm. This bill is, like has been said, this bill is already positioned or directed to those who have the concealed carry permit, but no one else. So what do they do? How are they penalized? As a correction to the senator, what he mentioned earlier, the firearm is there's nothing in the chamber. That's not true. So definitely available to answer any questions you have in regards to that. That's all I have on that. You have my written statement, and again, we are hope that this bill receives an unfavorable review. Thank you.
Thank you very much, Mr. Mojave. We have a couple questions from the committee for the panel. We'll start with Senator West, then we'll go to Senator Folden, then Senator Sidnor.
Thank you, Mr. Chair. Let me direct the questions to Mr. Jocelyn. How many people have carry permits in Maryland? Do you know?
As of 31 December, 175,632.
Wow. Do we know how many people are lawful gun owners but do not have carry permits?
I don't have the total number. I can tell you this, there are 318,476 HQL holders.
Okay.
Presumably they all have firearms. Many people have firearms that predate the HQL requirement. So that's certainly a minimum.
Do we have any data on how many accidental discharges have been committed by people who have carry permits?
I asked the Maryland State Police and they have no information on that.
How many carry permit revocations? What's the carry permit revocation rate here in Maryland?
0.001.
1/1000%. Okay. And let me come back to my education questions. If you, under this bill, if you accidentally discharge your gun and you're a carry permit holder, not anybody else, but only if you're a carry permit holder, you have to go back and take some training. And I'm looking at the training. It looks to me to be similar to the training that every gun owner has to have as a condition of registering as a gun owner.
It's very similar, and the flaw in this is that if the discharge was from a rifle or a shotgun, the training is inappropriate.
Okay. Are you aware of any element of this required training which is in addition to the training that's already administered to people who want to own guns?
Under the HQL current system and the carry permit system, it's all covered already.
So the people who make a mistake and actually discharge, I've already had this training.
Yes.
Okay, thanks.
It is, the operative word is accident.
Thank you, Mr. Chairman. Actually, I heard your question, but it made me think. Senator McCray, when you had those discussions with anybody in the state police or, the allied agencies, did they ever give any numbers of the ADs, the accidental discharges that they had reported them or any?
No, I was only following for my district.
Okay. I just wanted to, all right, thank you. That's all I had. I just wanted to give them a chance.
A question for anyone on the panel. When these discharges happen to date under current law, does anything happen to the gun owner?
Unless there was an incident where someone was injured, probably no one would even know about it. Anyone who suffers a gunshot wound, when they seek treatment, I believe under current law, the facility is required to notify the police that they're treating a gunshot victim. As far as property damage, it would depend on whether or not somebody even noticed it. I mean, technically speaking, if I have an accidental discharge as a permit holder and I managed to hit the target frame instead of where I really wanted it to go, I would have to report to an instructor, for example, Carla, to retrain me. But if I'm by myself at the range, I'm going to say, oh, darn, there goes $2 worth of wood and I have to fix it.
And that's the reality of how
That's
it
the
is
reality.
today. Is there anything, given the changes under this current Supreme Court's decision that was made some years ago, is this something that should be of some concern to the General Assembly? Again, I don't know how often people accidentally discharging, but as the senator mentioned, an accidental discharge in a rural area may be totally different than an accidental discharge in a more urban area. We have more people.
I understand what you're saying. Quite frankly, we didn't notice anything when the HQLs went in that had anything that promoted safety. We saw no positive benefit to it. As a matter of fact, I checked with the state police and they have no policy on an accidental discharge. They do have a policy of reporting intentional discharge, but they have no specific policy should a trooper experience an accidental discharge. Certainly, I believe if there was a problem, they would have created such a policy.
Thank you very much.
Senator Charles.
Thank you, Mr. Chair. This question is for Senator McCray. So I was looking at the Maryland Motor Vehicle Administration, and they have a driver improvement program. It says the driver improvement program is a 4 to 8 hour instructional program that is intended to provide a driver rehabilitation. You may have been assigned to the driver improvement program for one of the following reasons. You were referred by a district court judge. You were referred by an administrative law judge in the Office of Administration. You accumulated 5, 6, or 7 points on your driving record, or you were convicted or granted probation before judgment for a moving violation while holding a provisional driver's license. Now, everybody who gets a license has to go to driving school, and they go to driving school. It's a certain amount of hours they have to do, and then they get their license so they can actually utilize and drive a motor vehicle. The same with the individuals who get the license to carry. When you have situations like this, it seems like this is somewhat similar. Do you want to speak to that?
I would.
Mr. Johnson.
Senator Charles, I think you're absolutely right. I think that we have to understand that these are privileges. These are rights that we have. And like, as we're thinking about something, especially as strong as a firearm, it's just like, not to say that they're equivalent to a car, but we all take driver's classes. We all take driver's classes, and there are certain opportunities or there are certain provisions where you have to go back and take more driver's classes, the dip classes, because something went wrong from that standpoint. That's the same thing I'm saying with this. There's something that went wrong with the training that was received, and it's not like it's required by everybody. It's if you have the accidental discharge, there is something that can happen. There's something that is very, very challenging when that took place in urban, rural, but I see it from an urban jurisdiction, and we need to take a look at that. And I'm asking for basically 4 hours for you to get the appropriate training, to go back and get the appropriate training when you're talking about something that could have happened, that could have impacted someone's life. They may not be here again.
Okay. And Mr. Chair, I'd love to hear from the opposing side, like how they feel about that, being that that's something in place for motor vehicles, what you have to go through an entire training program in order to get your license.
I can speak to that.
Ms. Mooney, could you come to the podium, please? Thank you very much.
So as a firearms instructor, I'm giving up 2 days of my weekend. And in my classes, honestly, it's more like 18 hours. The training we provide, we can teach you the knowledge and the skills. We can't change your attitude. And unfortunately, an accidental discharge is often a attitude. It's an overconfidence, like was said. We give everything in us, and it's a passion for us to teach everything. Having quality training is difficult when the state of Maryland mandates training. Anybody can become that QHIC. I hate to say that, but it's true. With a minimum training of basics of pistol. What does that do in the big picture, when you teach someone to conceal carry, not enough. We teach a concealed carry class that teaches you about what that holster means, how it works, why it does what it does. And we're trying really hard to build an attitude of community to firearms owners as respectful, responsible owners, to take the time and to practice and know how their firearm works at all times, know how to take it apart and clean it, because a lot of times that's where they fail. They take a magazine out and forget there's one in the chamber. You can't take your gun apart without pulling the trigger. So again, it's an attitude of safety.
So quick question for you then on that, and in the position of a driver, if you go through these driving classes, you get your, driver's ed, and once you get your license, you run into problems, get all of these points accumulated on your license, and then you constantly go through it. At some point, the MVA revokes your driver's license.
As they should.
As they should, right?
Unfortunately, you drive every day if you have a license normally.
And so with this
And I
particular,
carry every day.
but with this
I'm an
particular
anomaly.
instance, with this particular instance, if somebody had accidentally discharged a firearm, they went through the training that you provide, the quality training that you provide, and then they still are just very negligent, because with certain things that you have to do when you're dealing with a firearm.
And it's an attitude.
But
that's
they're
important.
negligent with this. And then this is a second chance, pretty much. Hey, you got to go through this training again, just to make sure that you understand what you're doing. And then at some point, I don't know if your bill takes away the license after, if they keep on messing up and have an accidental discharge. This is just, you got to go through a training.
According
right
to this
now.
bill, I believe they have revoked for the time it takes to be recertified based on the training.
Okay.
So the 90 days to apply for it, it's still revoked until they've taken it and can prove that they've completed it successfully.
To me, the bill sounds like it's very similar to something that the state already provides for
H2O.
MVA. So,
And
but
concealed
thank-
carry permit holders have covered that 4 hours plus the 16 hours total. They have covered all those safety rules multiple times on the range, in the classroom, in person. And I think the downside is people don't take that responsibility and carry every day. They therefore don't handle their firearms every day. And unlike driving a car, when you do drive it every day, you have that constant practice. We don't have in the communities like Baltimore, we don't have a place for them to practice, not in Baltimore. So there's a factor right there. If there was more ranges, more time to spend practicing and getting comfortable, we probably have less accidents.
Come
as
on out
well.
to Prince George's County. We got a couple.
I wouldn't go to the one in Prince George's County for anything.
All right.
I won't even message it.
If you want to just stand there for a second.
Okay.
So I understand what my good friend Senator Charles is trying to say, but I think we need to give some clarity. So difference being, you go and you get driver training, driver's ed, you're given that one time, you drive every day or however all for the rest of your life. You're given firearms training and you're given this training, you're given a permit, you can buy, you can possess legally, right? So the difference being is that, so how many people, what's the average frequency do you think people get involved in vehicle collisions after they're given their license?
Depends on where you live.
It's about every 7 years on average. Every
So-
7 years, somebody gets in a vehicle collision. How many of those are actually reported to their insurance,
Yeah.
let alone to police or go in front of a judge? So, if you back in because you're in a hurry and you back out of your driveway and you hit your kid's basketball hoop, you're gonna be highly irritated. You made a
Right.
mistake. You got to fix your kid's hoop first, and then you got to deal with your car, right? So there's consequences associated with that. Whereas with an accidental discharge, a lot of those, if they go, and we don't have the numbers, but if they had those, I agree that, a rural area and a urban area are going to be,
And
there
end
are
result
potential
difference.
outcome differences by those locations. However, under the accidental discharges, if there were any of those potential instances occurred, obviously don't want that, but say someone is struck in a neighboring apartment. law enforcement comes out. There's a report written. There is a tracking record, and there's responsibility associated with that through the classroom you're given, right?
Yes.
And is there not liability associated with that?
Yeah, I believe there is.
So the difference being is that when you get involved about every 7 years, you could potentially have a collision. You know, a lot of things you have to go in front of a judge for those, any of the mechanisms that the senator referenced. You have to go in front of a judge to have any of those measures put in place to go to that driver improvement. You can't just show up and the instances I'm saying, you have to, and a lot of those are gauged by the injury severity, which is what I'm also talking about. The injury severity, if there's multiple collisions, were you impaired while you were driving? Did you strike someone? Did you take a life? Was there no one? Was it single vehicle? Was it multiple vehicle? So a lot of things that go into that. So I think to try to simplify it that way is, I understand the premise on why trying to do that, but I don't think that it's, would you agree that it's not?
Apples to oranges.
Yeah, they're two different things, because one requires multiple or appearances in front of a judge after a negligent act, which we can say an AD is accidental, or I would still say it's a negligent. An AD is you were negligent at the time. But it doesn't require you go in front of a judge. It doesn't require this. It doesn't have any reporting measures, doesn't have any additional reporting measures to you to then to go to the state police. So, and we don't have any numbers, concrete data to support that. Is that correct?
And to self-incriminate yourself, people are less likely to do that.
Right. Just like they are when they back into their kid's basketball hoop, they don't want to let their insurance know because your insurance is going to go up.
Yeah.
So they're just like, I'm just going to shut up and fix it and take it long. Right. So I understand the merits behind this, and I appreciate the merits behind the bill. I just don't know that we're there yet on how we're trying to assimilate this comparison. So thank you.
And our practice in life should be, if we do have something that is as important as self-protection, that if what we've been trained on is not in the forefront of our mind, maybe we self-report by taking more training on our own, not by being mandated to. As somebody who, like I said, I'm an anomaly, pants on, guns on, I wear my gun every day. Don't like going places where I can't. But I also know that safety is paramount, first and foremost. If I didn't feel like I was being safe in some way, shape, or form, I would not do it.
Safety is the paramount.
Absolutely. It is my one responsibility that I hold dear. Right.
Okay. Ms. Mooney, just real quick, what are the requirements to become a firearms instructor in Maryland? What are the training requirements, the prerequisites, the hours requirements?
So for the Maryland qualified certificates is, from my memories, and basics of pistol, from a nationally recognized training program, USCCA or NRA. I myself hold basics of pistol, rifle, shotgun, concealed carry weapons, range safety officer. The training I've had is years.
For the bare minimum to become certified to teach that
Basics
course.
of pistol.
Yeah. What are the hours qualifications? Like what are the?
Well, you do have to be able to shoot. A pretty difficult shoot. You've got to be able to show the manipulation of load and unload of a pistol in both revolver and semi-auto. And the classroom portion, you have to have the fundamentals of the nomenclature of each gun, how it works, and how be able to explain it.
Let's say you're proficient in all of those categories. What is the basic minimum hours requirement for that to become a firearms instructor?
So pistol
24 hours?
You're gonna have
20?
Probably 16 to 18 hours, because you're going to have the basics of training and then the actual class that you get your certification from. So you're going to get at least a 2-day crash course at minimum, but being able to produce the how-tos and being proficient in that doesn't come easily.
No, I get that. I was just wondering what, let's say
We
you
have
demonstrate the
people think it
proficiency.
does,
Yeah.
And then people who pay a trainer to give them the certificate when they didn't really understand maybe revolver versus semi-auto.
24-hour crash course.
I've had students,
Thanks.
my husband's a training counselor, and he's had people come that didn't know how to use a revolver, didn't know how to load one. and they want to be an instructor, and he did not give them a qualification.
No, appreciate that. Thank you. Senator, I saw Senator McKay. You want? Okay, go ahead, Senator McKay, then we'll go to Senator Sidnor.
So it's my understanding it's 24 hours, is it? And that's hence of my question about the amendment of bumping that to about 40 hours. So making sure that somebody who's training those people have the education that's there. So.
Thank you. You go through a training and you accidentally discharge. I've heard rather than the state mandate some, I guess, additional training, that we should leave it up to the individual who accidentally discharged to take it upon him or herself to do something so that they don't do it again. I'm curious, Mr. Mohammed, how do you suggest that this body, given the new state of the law, how does this body address that?
So in my course, in all of my courses, from the HQL all the way through the concealed carry, we overemphasize safety and safety principles of firearm safety. We overemphasize the fact that carelessness and overconfidence is definitely what causes some of these accidental discharges. In all of my classes, I even have a video of a former DEA officer who's in front of a group of students, children, in a classroom setting, where he accidentally shoots himself in the leg because he was overconfident, bragging about he was the only one professional enough to carry this particular firearm, and commences to shoot himself. Overconfidence and just completely careless. So we overemphasize that, and we teach not only our students, but we reemphasize to our own selves to not be overconfident. Just because I'm an instructor, that doesn't mean I know everything. That doesn't mean I'm invincible.
Right, but now they've taken the class, they've heard you, they've doing it. What do we?
Say again?
How do we respond? You all are the best and the greatest teachers in the world, and your students are still going out accidentally discharged. What should be our response?
Well, in the event someone's injured, that seems rather
but no, that's different, because then you have law enforcement coming in.
Yes,
I'm talking about someone who's accidentally discharging and no one's hurt. But does the accidental discharge show some carelessness?
On that person's
this
part,
body should be concerned with?
Yes, it does.
So how do we address that?
That part I don't know, sir.
Does anybody on the panel have an idea on how we address that? Because I assume, given some of the statistics that I've heard about the number of people who have been obtaining guns and their increases, this is going to likely be a problem that we're going to have to think about. So I'm curious from you all, the experts, what should we be doing as policymakers?
Unless the accidental discharge, which is usually negligence but could be a mechanical failure, unless it results in an incident that's reported, it's unenforceable. It becomes a moot point. There's no way to enforce it because no one knows about it other than the person involved, or there may be buddies around and none of whom are legally in possession of a firearm and are prohibited from possessing. They're certainly not going to report it. So the one group that's the most impacted by this are your most law-abiding citizens of all, your concealed carry permit holders. We're chasing a problem that really doesn't exist. We haven't seen any data presented today that indicates that there's a number of accidental discharges involving carry permit holders.
Thank you.
I'm sorry. Between that discussion, it just made me think of one more thing. So if a felon in possession of a firearm has an accidental discharge, again, I just want to point out, I mean, is there anything, if police aren't summoned, well, once again, we have measures in place for legal gun owners, but we're not holding to task those that are in possession illegally of firearms that are putting more people in far greater risk by the numbers of young people and people across the state that we're burying. Is that accurate?
It would be accurate, and it's also true that if a person is already prohibited and they are in possession of a firearm, they're already in violation of the law. And to report that would be a violation of their Fifth Amendment privilege. They could be maybe charged with the offense they committed,
I
but
didn't
not
even
with,
think about
but
that,
not
but
with
thanks.
failing to report it.
Okay, thank you, John.
All right, seeing no further questions, thank you all very much.
Thank you,
Thanks.
Mr.
Thank you, Senator
Chairman.
McCray.
I'd like to wish you all a happy Groundhog Day.
Oh, yeah. Early spring. I'm willing. All right, now we'll move on to Senator Waltreicher. Senate Bill 373.
Thank you, Mr. Chairman, members of the committee. This bill will be brief. Senate Bill 373 does something simple. It makes mail theft a crime in Maryland. There's a reason why mail theft is not currently a crime. That's because traditionally the mail, which is interstate commerce, is treated only as a federal offense. But what we've seen is that in jurisdictions with higher rates of crime, mostly large states, 14 states now, the U.S. Attorney's Office has become overwhelmed. Here in Maryland, the U.S. Attorney's Office traditionally only prosecutes mail theft where the loss exceeds $1 million. That's a lot of money. The U.S. Attorney is going after big fish, and that's a good thing. But because of resource constraints, it means those who are doing smaller levels of mail theft are getting off scot-free because we don't have a state level statute to prosecute it. In addition to routine mail theft, and of course, for the victims, there is no such thing as routine mail theft, we see an increasing brazenness in the robbery of arrow keys. Arrow keys are the special keys that postmen and women carry around to open the blue boxes. These are now being stolen at gunpoint in broad daylight in your community and recently in my community as well, posing an incredible danger to our federal employees as well as the surrounding communities. And so this bill simply adds to the ability of our local prosecutors to do what our federal prosecutors wish they could do, but are no longer doing because of the resource constraints. The United States Postal Inspection Service, which is the primary law enforcement agency who investigates these crimes, supports our states having this tool so that they can bring these to our local states' attorneys. With that, Mr. Chairman, I would ask for a favorable report on Senate Bill 373.
Good morning, Chair Smith, members of the committee. My name is Forrest Gilman Riley. I'm an assistant state's attorney with the Montgomery County State's Attorney's Office, where I serve in our Special Prosecutions Division. We specialize in complex fraud and misconduct by public officials. The United States Postal Service is unique. It is the only organization that can carry the mail. It's guaranteed through its universal service obligation to everyone in this country. When someone steals mail out of the care of the Postal Service, the harms are manifold. The first is obvious. It deprives the intended recipient of that piece of property, the mail. It also deprives both the sender and the recipient the obligations that they're entitled to have their mail carried privately and securely by the Postal Service. It compromises personally identifying information about the sender and the recipient. It thwarts the Postal Service's lawful custody of the mail prior to delivery, and it undermines the ordinary function of government. Courts, voting systems, taxes, all of these things heavily rely on mail. The taker of mail has no way of knowing what is inside prior to taking that object. Once they've completed the theft, then they can find out what's inside. They get the prize. It could be nothing. It could be valuable personal information. It could be a check that could be washed. The content isn't itself explicitly important because the mail itself is a special thing carried through a government service to allow people to be connected to each other, to enable commerce, and to enable governance. Under current law, taking of a piece of mail, if it doesn't have a face value unto itself, would be a misdemeanor theft of property less than $100. This would change that. The theft of mail would be treated similar to counterfeiting under 8601 of the criminal law article, which is a 10-year felony for essentially the same reasons. Just as a counterfeited check could be a penny or $1,000 and still be a 10-year felony, the same is true here. We urge a favorable report, and we thank you for your time.
Good day, Chairman, members of the committee. I'm Louis D'Arienzo. I am a United States Postal Inspector and Chief Counsel of the United States Postal Inspection Service. The Postal Inspection Service is the federal law enforcement and security arm of the Postal Service. Our agency works diligently to enforce the criminal laws and protect the United States Postal Service, our customers, and our nation's mail stream. Unfortunately, over the past few years, mail theft and robberies of USPS letter carriers have risen dramatically. Furthermore, while in the past, this criminal activity was predominantly committed by lone actors in small informal groups, it's become very common for large organized criminal organizations and groups to be involved in these crimes. Many of these robberies are now for arrow keys, otherwise known as postal keys. These keys permit individuals to access collection boxes, relay boxes, parcel lockers, and other mail receptacles. Once in possession of these keys, they can steal mail from these receptacles. The stolen mail is then used to commit financial crimes, often with devastating results to the elderly and other vulnerable victims. We've taken significant steps to address this through prevention efforts, education, and enforcement. We work with our local, state, and federal prosecutors on these cases. This legislation would increase that enforcement. It would enhance it. It would supplement, not supplant or usurp federal regulations and laws in this area. While federal charges may be appropriate in many cases, or for some members of a criminal group, state charges may be the most appropriate for some groups or for other individuals. Also, there is no federal juvenile justice system. Therefore, if a juvenile is arrested for committing mail theft, there's often nothing that we can do with that. We're proud to work with federal prosecutors, state prosecutors, and Maryland state law enforcement to address this. And we believe that this bill would supplement our efforts in this effort. Thank you.
Good morning. My name is Debbie Feinstein. I typically am here on crimes or bills that relate to special victims issues. And this bill is actually no different. It actually has a carve-out section for vulnerable people and elderly people if their mail is stolen under certain situations. I'm testifying on behalf of the Maryland State's Attorneys Association today, as well as my office, the Montgomery County State's Attorney's Office. I also chair the Elder Vulnerable Adult Abuse Task Force for Montgomery County, where we see issues related to financial exploitation and abuse and neglect come before us. And we're talking about those cases, quite often. I also come before you to share a personal story. My parents actually live in Leisure World, which is in Montgomery County. And last year they went to mail in their tax checks and they brought substantial amounts. And they brought their mail after they wrote their checks to the blue postal box that sits in front of the shopping center in Leisure World in Rockville, Silver Spring, Maryland. They put their checks in there, assumed all would be fine. And they come to find out within a few days that those checks have been washed and cashed and were not at the IRS and the state taxing agency as they should have been. This was devastating for my parents. They felt taken advantage of. They had gone to special care to mail their mail in the blue box rather than just simply sticking it in their mailbox at their home. It took them, a number of days working with the bank, sending emails, making phone calls to remedy the situation in terms of them getting their money back and them being made whole. But my parents are fortunate for many reasons, and I'm fortunate for many reasons because they had the wherewithal to address this, to notice it and to address it. Many of our seniors do not have that capacity. So this particularly affects them, but it affects everyone. And I would urge this committee's support for Senate Bill 373. Thank you so much.
Thank you, Mr. Chair. I was just looking for clarification in terms of this. Is this with the current law? Are we working in conjunction with the U.S. Attorney? So for this bill, if this bill goes into place, are we working directly with Eric Barron, our U.S. Attorney for Maryland?
So the short answer is yes. But the U.S. Attorney has made clear to us as legislators here in Maryland, of course, the U.S. Attorney served in this body, that he cannot prosecute all cases of mail theft. And his focus is on the large players. And what that means is that the small players, and they're not small, it's just losses under $1 million generally. Obviously, for some people, a loss of $50,000 is their life savings. So it's not small for them. And of course, as the Postal Council mentioned, this doesn't supplant his authority. It simply adds to our authority.
And that just leads me to one last question. So if, like right now, Eric doesn't have a lot of money over there, they need to focus on a lot of large cases. And so we push this to our state's attorney's offices and they can start focusing on these cases. Can you get a state charge and a federal charge if Eric somehow ends up getting a bump in the budget and he gets additional state's attorneys in his, U.S. attorneys in his office to help out?
So this is a large theoretical question, but the answer is yes. Under the Constitution to the United States, the state and the federal government are separate sovereigns. And so there is no double jeopardy issue of bringing both federal and state charges. In reality, because of resource constraints, that is unlikely to happen. The U.S. Attorney will indicate that he is taking the case, or the state's attorneys will indicate that they instead will take the case. The likelihood of them both taking a case is very tiny.
Thank you. You know, I'm new to the committee, trying to understand a lot of the legalese now.
Yeah.
So thank you, sir.
Thank you, Mr. Chairman. The gentleman on the end there, is it Eric?
My name is Forrest Gilman Riley. Yes,
Oh,
Senator.
Forrest, I'm sorry. So I want to just point out, one of the comments you made is like really stuck with me. I love this bill. I support this bill, but the content isn't necessarily important, or the value of the package or the item that's stolen, right? So I agree with that. I think that's an important element because you don't know what's inside of the value of the package. And I link that, and I bring that up because we just had a discussion about this very thing when we were talking about the value of a firearm, because it shouldn't matter the value of a firearm. It's that threat that poses to society. But yet we keep a firearm a misdemeanor violation, the theft of a firearm, unless it's valued at more than $1,500. But every one of these sections of all portions of this, except the very first one, which is like basically one piece of mail, they're all felonies.
Yes, Senator. I believe the bill as amended does, was there the?
We can talk about it. You can,
Thank you.
yeah.
It's my understanding, at least in the House, there is a sponsor amendment offered that adjusted the number of the penalties. And in that instance, there were all of the offenses would be felonies. We are very open to this committee and the House's feedback on arriving at a set of penalties that you all believe is reasonable as to why we selected these. So the theft of a piece of mail as amended would be a felony punishable by a maximum of 10 years. And that is to directly mirror what has previously been done with counterfeiting and to make it also similar to use and disclosure of a credit card.
Sir, I'm not actually disputing that part of it. I'm just saying, I'm pointing out
I
that
agree with you.
I'm pointing out that we're saying that someone can steal mail, a piece of mail, and across the board, it's a felony because you went into somebody's deposit or you used the arrow key. Any of those are felonious acts, punishable up to 5 years or 2 years, 5 years across there. One of them's 99 years, but the theft of a firearm is not. It's a misdemeanor. I just point that out because I like the bill. I value your opinion, but I just also am concerned that this body wants to put and move and minimize the threat value of something that's significantly more of an immediate threat to society than someone reaching in somebody's mailbox. Thank you.
Thank you, Senator. We really appreciate it.
Thank you, Mr. Chairman. follow up for you, Ms. Feinstein, and I don't have to answer any more detail than you're comfortable with because it involves your parents, but I just wanted to understand your particular case so I can put it in the context. Your parents live at a well-known large senior community.
Yes.
They were on the premises at a designated place where you would deposit mail, outgoing mail.
Immediately outside. It's the
Immediate
shopping
out-
center that's adjacent to Leisure World.
Okay, it wasn't on Leisure World, but it was at a shop.
Basically is, yeah.
And then, do you know if that incident, the thieves absconded with, I'm just trying to get a magnitude, all the mail in there, they just grabbed the whole dang thing.
Yes, that's my understanding, that my parents were not the only individuals affected, and this is not the only time that mailbox in particular has been targeted.
And then how did your parents discover the problem and how quickly? Just for my own
Right.
edification.
It was my dad checking their accounts. He's all over it. But many people wouldn't even realize that that's what happened. If the check is washed and deposited elsewhere, and they could find out, a significant amount of time later that, oh, in fact, their taxes were not paid. But again, fortunately, given the wherewithal, they were able to determine it right away.
Did it appear in, I'm just trying to understand the cleverness and awfulness of criminals, but they were able to take a check, wash it, which is then change who the payee was.
Correct.
So in your parents' bank statement, ultimately, check 0075 went through, but the payee is not the IRS or the federal government. Suddenly it's somebody else, and for an amount that has no relationship either to the
That's
situation.
correct. That's correct.
Thank you.
Yep, absolutely. And thank you for the questions.
So for the state's attorneys, I guess, is the U.S. attorney saying that they can't prosecute this because of the penalties are not high enough, or there's just no statute available?
So I'm going to speak to it very briefly,
Yeah.
but I would obviously defer. Okay, you know what? I'm going to defer.
Sure.
Yeah. No one to fold.
Sir, it's not that they can prosecute them. They don't always have the resources. It's not always appropriate to prosecute everybody federally. It's much like bank robbery, right? Not every bank robber is prosecuted federally. Some are prosecuted federally. We know that some are prosecuted in our state courts. So they have to have thresholds because obviously they have resource limitations, as do all of our prosecutorial offices. So those thresholds often, they don't reach the threshold to prosecute them federally. Now, if there's a robbery of a letter carrier, especially an armed robbery, most often than not, those are charged federally. Because those are obviously much more serious.
I guess the question was more, so we have for section 3905 of our criminal law article has opening a letter without permission. It says a person may not take or break open a letter. Okay, so can't do that. Seems like it'll qualify. And then the penalty is it's a misdemeanor subject to imprisonment of 6 days and a $15 fine. So I wonder why the bill wouldn't have been drawn to that section of the code, and then maybe you just go to seek to enhance the penalties there.
I can't comment on that.
Okay.
I was not.
It seems it would be a much more artful and simplistic way to get to where you're going, but I don't know. Okay. Cool. I think we could probably solve that in like two sentences instead of an 8-page bill. Okay, cool. No, this is good. All right. Any other questions from the committee? Thank you. All right. Awesome. That'll conclude. Well, actually, hold on. Do we have anyone else coming for this?
We have Jason Shoemaker and Robert Doyle.
Jason Shoemaker and Robert Doyle. Oh, come on. Yes, please come forward, please.
Good morning, Mr. Chairman, Mr. Vice Chairman, and the committee. My name is Bob Doyle. I'm with the State Legislative Committee of the Maryland Federation of the National Active and Retired Federal Employees, or NARF. And NARF is here today for the continuing protection and benefit of all Maryland seniors, asking for favorable report on this bill. While mail theft is prohibited by federal law, if SB 373 becomes mail law, excuse me, Maryland joins the numerous other states with state mail theft laws. We think this is important not only as an additional deterrent factor, but also to allow state prosecution of someone charged with mail theft if federal prosecution does not occur for any reason. SB 373 addresses mail theft in Maryland in several ways, including the theft of mail with the purpose of identity theft, with special provisions when the identity theft will happen to elderly persons 68 years old in this bill or vulnerable adults. Identity theft from seniors, major crime. Statistics from the FTC for 2022 showed nationally over 177,000 reports of identity theft for consumers 60 years old and older. Maryland had 20,000 reports of identity theft total, not for all ages, making us the 12th worst in the country. I couldn't find hard statistics on identity theft by mail in Maryland, but I can tell you seniors know that this is a very, very important thing and a tough thing for them to go through. The identity theft affects everyone. I'm sure somebody in this room has had that happen to them. Very, very serious for seniors. We appreciate the special emphasis in the bill on the strong penalties for theft from seniors. And because we support these kind of bills that help seniors stay in Maryland because they feel protected and not leave for Florida or anyplace else, we hope for a favorable report on this bill. Thank you. Thank you, sir.
All right, thanks. With that, that'll conclude the hearing for Senate Bill 373. We'll now move on to Senate Bill 391. Senator Kelly.
Thank you, Mr. Chairman, and members of the committee. And I'm going to go ahead and bring my panel up so we can keep it moving if that's okay with you all. We have Debbie Feinstein coming right back, Sarah David, Carrie Terrell, and Melanie Shapiro. They're coming to the table with me. So I'll get started. Thank you for the opportunity to introduce Senate Bill 391, which is a piece of legislation related to the statute of limitations for stalking, sexual extortion, and revenge porn. So I'm super excited to be here to talk to you about those issues today. This deals with the statute of limitations for these misdemeanors. I wish that Senator Muse was sitting in his seat because he reminded us yesterday in that hearing that sometimes those statutes of limitations are really important, right? So with that in mind, sometimes that statute of limitation can really get in the way of doing the work that we need to do. And for the crimes of stalking, sextortion, and revenge porn, the 1-year statute of limitations has not been working in the state of Maryland. There are 26 misdemeanors that currently have no statute of limitations, and I have attached that list to my testimony so you can see what those are. But some of them are sex trafficking, persuasion of a minor, perjury, bribery. Again, my written testimony has the list of all of those. One of the recommendations from the Governor's Family Violence Council Stalking Subcommittee is to put these crimes, sexual extortion, revenge porn, and stalking, into that list of misdemeanors that would not have a statute of limitations. That's because the 12-month timeline is really extremely difficult for some of these cases. There's a couple of reasons for that. Number one, and this is particularly true in the revenge porn context, delays in knowledge of the crime, right? Particular for sexual extortion, you see a lot of fear of reporting, which can cause delays in reporting. And of course, the time that it takes to investigate cases that involve technology and electronic devices. And so all three types of stalking, sexual extortion, and revenge porn cases all face barriers in that way. And we're going to hear about that from the panel, so I won't get too deep into it. I will remind the committee, because this issue did come up related to stalking back in 2022. There was a piece of legislation that would have made stalking a felony. This recommendation is not doing that. We are proceeding with the attempt to remove the statute of limitations. That's an alternative approach that I'm hoping will be working. So there's no making anything a felony. There's no increase in criminal penalties in this legislation. You will see that the OPD has signed up in opposition. They have, I think, a very narrow concern related to this. I believe their concern is related to the revenge porn context, but we have been talking with them, and I'm hoping we'll be able to have conversations with them that are productive. So we'll hear their concerns, but my goal is to figure out how we can make this happen. after we understand their concerns a little bit better. So with that, I'm going to pass this on to the panel. I already introduced them, but just so you guys know, of course, Debbie Feinstein, you just heard from her written testimony, did not get submitted into the file, but you all have it in your emails. My staff sent it to you. Sarah David should be here. She's a well-known friend of the committee. She's also, though, with the Office of the State Prosecutor for Senator Charles's benefit, because he's new to the committee. I didn't know what that was. So I will tell you that they have a really important job of enforcing political corruption and police misconduct cases. And so they had 58 special victims cases last year. So their testimony on this issue is really, really important to us. And of course, Carrie is with MCASA and Melanie Shapiro with the Maryland Network Against Domestic Violence. With that, I'm going to urge a favorable report and pass it off to the panelists. Debbie, I think, is first. Yeah.
Good morning again, or actually good afternoon. Debbie Feinstein, Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I'm here in my capacity as a prosecutor and for Montgomery County, as well as on behalf of the Maryland State's Attorneys Association. The work group that Senator Kelly referenced was started several years ago. It became regarding stalking and the Family Violence Council. Both Senator Kelly and I both sit on the Governor's Family Violence Council, and we're allowed to bring kind of things of concern to the committee and ask to have a subcommittee formed. So we formed the stalking subcommittee several years ago, recognizing the close link between stalking and lethality. 54% of female homicide victims have reported stalking to police before they were killed. 76% of female homicide victims have been stalked by the person that killed them. This nexus is close, which is why we asked a couple of years ago to make stalking a felony, recognizing the dangerousness that we see in that behavior. There was not a lot of appetite for that. So we thought about, well, how can we be more effective in prosecuting stalking and revenge porn and sextortion, which are all gateways for greater and more serious felonious crime? We came to the conclusion that extending the statute of limitations on stalking, revenge porn, and sextortion would give the state more time to investigate these cases, more time to have the electronic devices downloaded, reviewed, extracted, all of the things that need to happen that there's typically a backlog for. And often not even the backlog is the issue, it's the password issue. Having to break into phones, computers, etc., often requires special keys to do that. And we actually also often have to consult with the federal government in order to break into those devices. Needless to say, the process is very long. In addition, we have the concern about victims of intimate partner violence. They may be gaslighted, shut down, afraid to report what is happening to them until they are safe, and it may be many months or even years later. So for those reasons, we urge a favorable report for Senate Bill 391. Thank you.
Oh, good afternoon, Mr. Chairman and members of the Judicial Proceedings Committee. My name is Sarah David. I'm the Deputy State Prosecutor at the Maryland Office of the State Prosecutor. As Senator Kelly alluded to, our office is tasked with investigating and, where appropriate, prosecuting cases involving political corruption, police misconduct, and election law violations. We're here with our prosecutorial colleagues from around the state in support of SB 391 and want to thank Senator Kelly for her leadership on this issue. Our investigations have resulted in charges related to these offenses at both the state and federal level, including a Baltimore City prosecutor who for years used the power of the grand jury and its secrecy to obtain phone records for his girlfriends and to find information about these women, including calling one woman's OBGYN and asking a hotel where one was staying how many beds were in the room. The women were unaware of the behavior, but did experience unusual things, late night phone calls, and when they finally came to report it, it was years after the behavior was initiated. Our office also investigated and prosecuted a mayor in a Maryland city who put pictures of a former romantic partner on websites with offensive comments and chats. The victim would not have known about that conduct if she had not been recognized in the images by someone who knew her. It is absolutely heartbreaking for the people in our positions to tell a victim who is victimized through revenge porn, stalking, or sextortion that they are too late. Remember, even if the victim only waited a month or 2 months from the time they found out about it to report these cases, the forensics and investigation can take a full year. In cases with public or powerful perpetrators, victims are even more likely to delay this reporting because they feel like nothing will be done because of their perpetrator's position of power, especially if it's a police officer or a person in politics. We shouldn't have to tell a victim staring at a computer image of herself that there's nothing we can do because she didn't come to us in time. Thank you for considering this important legislation, and we'd encourage a favorable report.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. I'm Carrie Tyrrell, the supervising attorney at the Maryland Coalition Against Sexual Assault. I am here at the invitation of our director, Lisa Jordan. MCASA is the coalition of the rape crisis centers across the state of Maryland, and our office includes the Sexual Assault Legal Institute, where we provide direct representation of survivors of sexual assault in Maryland. We are here in support of Senate Bill 391. The Sexual Assault Legal Institute, or SALI for short, works with numerous survivors who have experienced sextortion and revenge porn. Many survivors who contact SALI have serious concerns about the privacy of their intimate images and videos. Some even have text messages from their abusers stating that they have shared those images and videos, but the survivors don't know where they've been posted or whom they've been shared with. Currently, we have to tell those survivors that if those images have been shared and aren't found within a year, they won't have any criminal legal options. Survivors, understandably, are baffled by this. Once an image is on the web, it's virtually impossible to remove. Survivors face a lifetime of their friends, families, coworkers, and employers having access to those private images. This can result in a lifelong mental health consequences for victims, damaged relationships, and social isolation. One high school teacher told me that every time she looks out at a new classroom full of students, she wonders how many of them have seen non-consensually posted videos of her engaged in sexual acts. Survivors can't understand why their abusers get off scot-free if they aren't caught within 1 year, while the survivors themselves have a lifetime of consequences. For those reasons, MCASA requests a favorable report on Senate Bill 391.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. Melanie Shapiro, I'm the Public Policy Director with the Maryland Network Against Domestic Violence. Don't want to repeat what my panelists have already said. What I do want to explain, however, is that stalking, when the law was first enacted, looked very different than it does today. It used to be somebody literally following you in your car, showing up outside your home or where you work or where you might go for a jog. Now, for the most part, stalking is all online. And so the removal of the statute of limitations for these crimes, two of which didn't really exist 20, 30 years ago because technology was not there. They do exist now, and our laws need to keep up with technology. The forensics that are needed to build a case are very complex and require a level of expertise. There's only a certain number of officers that have that level of expertise, and ensuring that those cases make it to those officers and that they have sufficient time. We don't want anybody wrongfully charged. We want cases to be thoroughly investigated before they're brought to prosecution. And the removal of the statute of limitations, we think, is the appropriate approach to, one, give the victims the time, one, to discover that they have in fact been victimized, to gather the courage that it takes to actually report the offense, and then for law enforcement, the sufficient time needed to build a case so that it can be brought to prosecution. So for all of those reasons, we're urging a favorable report on Senate Bill 391, and would like to thank Senator Kelly for her leadership on this.
Excellent. Well, thank you very much, Senator Kelly. You definitely brought the all-star panel. It's been great working with all of you. Questions from the committee? All right. Well, let's actually we'll touch base soon because I'd like to work on this, and maybe we can revisit the I know the stalking felony conversation, but we can revisit that. It's just conceptually, it's hard to, we'll talk more about this, but just it's hard to have an unlimited statute of limitations for stalking or for even sextortion, because those are more immediate and kind of time, it seems like. And then, and I know Sarah talked to me more about that offline, but obviously the internet is forever for the revenge porn, and that makes perfect sense. But I just, want to continue those other conversations with the other two. But otherwise, this is great. Thank you very much.
Thank you, Chair Smith.
All right, I think we have, yeah, we got Diana. Do we get Diana Beeson? Ms. Beeson, come on up, and then we have one person joining us on the opposition panel virtually.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Diana Beeson, and I currently have the pleasure of serving as the Engagement and Policy Initiatives Manager for Turnaround. Turnaround is the designated rape crisis center for Baltimore City and Baltimore County and a comprehensive domestic violence center. Crisis response, victim-centered advocacy, legal referrals, trauma therapy, and community education are core components of the agency's work. Turnaround is the designated regional navigator for Baltimore County and Howard County, providing services to human trafficking survivors. Turnaround is a member of the Maryland Coalition Against Sexual Assault, the Maryland Network Against Domestic Violence, and the Maryland Human Trafficking Task Force. Turnaround and the Maryland Human Trafficking Task Force respectfully request a favorable report on Senate Bill 391. Eliminating the statute of limitations for prosecuting sexual extortion, revenge porn, and stalking empowers survivors, many of whom have had their decision-making ability and autonomy taken away. It's time to give it back. Stalking can often accompany domestic violence. Delayed disclosure is a reality for many survivors and can happen due to a variety of complex and overlapping reasons. In a society where all too often victims of crimes are blamed for events that occurred to them, feelings of guilt, shame, and fear are often internalized. Clients of Turnaround have experienced stalking, revenge porn, and extortion. Our advocates report the challenges clients have had with proving stalking and the emotional toll of logging acts, how long that process can take, and the additional trauma that is experienced. Another client discovered they were a victim of revenge porn after they discovered a digital image more than 1 year after it was posted. Digital content is permanent and leads to a victimization that can last a lifetime. Healing has no timeline. The ability to file charges and prosecute in these cases should not have one either. On behalf of the Maryland Human Trafficking Task Force and Turnaround, we request a favorable report. Thank you.
Thank you very much. No questions. Thanks. All right, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel, and joining us virtually, we have Ms. Watts.
Thank you. I'm Kimber Watts. I'm an attorney with the Office of the Public Defender. We certainly understand Senator Kelly's points about waiting until it's safe to report things like stalking and domestic violence related incidents. And that, of course, is why we've been talking to her. As it relates particularly to revenge porn, obviously it may be years before someone knows that that has even happened and can be aware of that harm. We do have some concerns, and as Senator Kelly said, that's why we've been talking to her. Our first, I think, more minor one is one that we've seen play out in national news in the not so distant past, and that is people who were aware of harms that had been done to them and were safe to report them, but didn't until somebody received professional success and then made allegations to undermine that success. While this may most publicly impact people running for office and high-profile judgeships, it undoubtedly happens in the business world too. So I think that that's something that the legislature needs to be considerate of when passing laws. That being said, we are particularly concerned about eliminating the statute of limitations for revenge porn as it relates to teens and young adults. We have concerns about how this will impact individuals potentially decades past their bad decisions. In our experience, individuals are most likely to share intimate photos impulsively in the heat of a moment during a breakup. This does not excuse that behavior in any way, but we worry that for young people and individuals in their 20s for whom this impulsivity is part of normal development, it doesn't necessarily reflect the adults that they will become. And for those reasons, we ask that you either issue an unfavorable report or amend the bill to include some statute of limitations, perhaps a 5-year statute of limitations or a provision that begins the tolling of the statute of limitations at the time the harm is discovered. Thank you.
Thank you very much, Ms. Watts. Questions from the committee? Seeing none, thank you very much.
Thank you.
That'll conclude the hearing for Senate Bill 391. We'll now move on to Senator Folden with Senate Bill 396. Actually, Senator, would you like to bring up your panel?
Yeah,
All
they
right.
want to come up.
Mr. Schellenberger, Mr. Cox. Williams.
Schellenberger will not be here.
Oh, okay, got it.
I don't blame you. Okay. Mr. Chairman, members of the judicial proceedings, for the record, Senator William Folden representing the 4th Legislative District. For you today, I have Senate Bill 396 dealing with the criminal procedure, stops and searches, cannabis odor and admission of evidence, Drug-Free Roadways Act of 2024. This bill is attempting to correct a wrong, an error that the legislature made last year whereas they allowed or permitted the odor of burnt marijuana or strong odor of marijuana emitting from a vehicle was now no longer RAS for a traffic stop. And that's really what this bill comes down to. This bill is attempting to remove the prohibition against law enforcement officer from initiating a traffic stop or search of a motor vehicle based solely on the odor of burnt or unburnt cannabis. RAS is not proof beyond a reasonable doubt. It's not even probable cause. The threshold of RAS and what it's required for reasonable articulable suspicion that someone is operating a motor vehicle, especially when you have single occupants within a vehicle with a strong odor of marijuana emitting from the vehicle while it's driving down the roadway, is a strong indicator that that person is in violation of law and potentially impaired at the time. We're seeing these increases in motor vehicle collisions involving those who are under the influence of said CDS or actually it's not a CDS anymore, marijuana. And this strong odor is definitely discernible by law enforcement and those in the community. I mean, we just had a bill yesterday or the day before about members of our community within our HOAs wanting to have policies so that people don't have to smell the odor of smoke, but we all can say that it's the odor of marijuana within their HOAs because they live in these packed communities. The concerns I'm pointing out are, this is a public safety matter. If someone's driving down the road and they're drinking a beer, they have a beer in their hand, the officer can pull them over. If they're smoking a joint and they have it down next to them, we may not see the actual ingestion at the time of, but we certainly can equate that a single vehicle occupant with a strong odor of marijuana emitting from the vehicle is going to be more than the legal amount, as well as potentially in the current act of violating the rules of the road of driving while impaired. So with that, I'm happy to take any questions. I'll let my panel go, and I would ask for a favorable report on SB 396.
Good afternoon, members of the committee. My name is Moreau Williamson, and I'm an assistant state's attorney for Anne Arundel County. I'm testifying on behalf of the Maryland State's Attorneys Association. I've been a prosecutor for 16 years, and I've been focused on felony narcotics cases for almost 9 of those years. It is in the interest of public safety to pass SB 396. In my experience as a prosecutor, the odor of cannabis within a vehicle can lead to the seizure of other items such as handguns and drugs such as fentanyl. Passing SB 396 would return this important investigative tool back to law enforcement and would aid in the detection in these otherwise undetected deadly items. Gun violence and drug addiction and overdose are a major issue in Maryland and around the country. This bill would enable law enforcement to prevent crimes and deaths before they happen by taking firearms and drugs off of the street. We've all heard the saying, an ounce of prevention is worth a pound of cure, and this bill would serve as the prevention.
You don't just have to take my word for it. There are statistics on this right now from Montgomery County. In Montgomery County, gun seizures are down since this law was enacted in July. The Montgomery County Police Department reports that as of this time last year, 119 guns were seized. Now there's only been 69. The Maryland State Police, who is charged with traffic enforcement in Montgomery County, in 2023, before the law changed, there were 21 cases involving firearms from vehicles. To date now, since this law has changed, there absolutely none. Furthermore, it's contrary to the goal of public safety to prohibit law enforcement from stopping a vehicle that clearly smells like cannabis and to let a driver continue driving down the street with law enforcement unable to so much as conduct a traffic stop. This would be like an officer being legally prohibited from stopping a vehicle that smells like alcohol driving down the street. The odor of cannabis has become ubiquitous on the roads of Maryland. I'm regularly in the car and can smell cannabis while driving on local roads and highways. I think we can all agree that the dangers of this is self-evident. The citizens of Maryland deserve better. I urge you to support SB 396.
Go ahead. I'm just going to agree with Mr. Cox and Ms. Williamson, Mr. Vice Chair, at this time and answer questions if necessary.
Mr. Vice Chair and members of the committee, I'm John Cox, Deputy State's Attorney for Baltimore County. Also speaking on behalf of the Maryland State's Attorneys Association in favor of Senate Bill 396. As the senator explained, it absolutely makes no sense that an officer can see somebody raise up a can of Budweiser while they're driving and be able to pull that car over. And yet if that car drives past them and I'm older than all of you, I've been hearkening back to Cheech and Chong in a movie Up in Smoke. But if they were to see the smoke wafting from the car and smell the odor of marijuana, they can do nothing. This makes absolutely no sense. It is a danger on the roadways concerning that particular offense. It's also, and obviously it's against the law to be smoking cannabis while you're driving. It's against the law for an occupant of a vehicle to be smoking cannabis while they're in an operating vehicle. I frankly would extend this a little bit further to go to person. So if somebody were to walk up or an officer is on a school playground and smells the smoke coming off of a person, they can't even stop them with the law as it exists right now. It is a violation for them to be smoking in a public place, but they cannot just on the odor stop that individual. The other piece of this legislation that is addressed, that hasn't been addressed at this point, is it also takes out subsection C of the law as it exists right now. And I have no idea where this came from, but somehow it got into the legislation last year that you can't even use the results of a consent search. So if, for example, an officer pulls over a vehicle or walks up to somebody and says, do you mind if I pat you down? Or if they pull over a vehicle for a valid reason and ask for consent to search, that if that was because they walked up and they smelled this odor of marijuana, you can't even use that. If the concern was the viability or the reliability of that officer saying that the person consented, we now live in the age of body-worn camera. So that issue of consent is easily addressed if there's any sort of challenge to it. We'd ask to support Senate Bill 396.
And Mr. Chair, if it would please the committee, I do want to make sure that there was some really great data that came from Montgomery County in closing in regards to that in 2022, 80% of Montgomery County Police's handgun forfeitures, seizures, not forfeitures, seizures, were as a direct result of traffic stops involving marijuana. So, and with that, I would ask for your support of SB 396.
Has Mr. Kroll, have you testified?
I'm agreeing at this point in time.
Understood.
I can say
Okay.
that. You know better than Ms. Williamson and Mr. Cox.
Got it. And Mr. Schellenberger also signed up. Is he with us?
He's not here yet.
Got it. Understood. All right. Questions from the committee? I see a question from Senator Sidnor.
Thank you. Question for the sponsor. And again, I think anyone who's spoken to me knows I can't stand the smell of that stuff. However, in driving, there are times when there's this whiff of something. I think when I was young, I thought it was a skunk. Now I'm older and I realize it probably wasn't. But the thing that, and one of the reasons why I voted for this bill last year, why I would have difficulty supporting it this year is because it has not been quite clear to me how an officer determines whose car it is that that smell is coming from. And given your uh, uh, expertise and
Say background.
thank you very much. How did you go about doing that on your other job?
So look, this is an important component. That's a great question. Without any hesitation whatsoever, I'll say it's a great question. RAS, reasonable articulable suspicion, is the threshold to create that investigative detention, right? That investigative stop. And so if there's a cluster of cars, you may not be able to discern which one it is, quite honestly. And that point, you can't take that stop because you would then be potentially seizing someone's during the stop or an investigative stop to determine that. That's not what this is about. This is when there's clear, discernible, single vehicle in front of you, it's wafting out smoke, and the law is clear. As the state's attorney pointed out, it's very clear. It's not just the driver ingesting it. No one can ingest marijuana while a motor vehicle is in motion. It's just like alcohol. So the RAS for the stop is there, and it is justified. And this is a life-saving measure and a tool that is needed for law enforcement to save lives on the roadways, the hearings we had yesterday, as well as getting these illegal guns off the road. The RAS, you're very familiar with this. I mean, you're an attorney, you're very brilliant, you understand that, right? It's a lower threshold. Then you have to, during that investigative stop, then you got to get to, if there were an arrest, obviously you got to have probable cause. But the reason for a stop, that threshold is down where it is because it is an investigative stop.
Thank you.
Yes, sir. Thank you.
Thank you both. Senator James.
Thank you, Mr. Chairman. Thank you, Senator Folden, for bringing the bill. Couple of questions that I want to get clarification on. Is there any, and you all can get back to me because I can imagine this is coming a little out of broad.
They're all way smarter than, they'll have your answers.
I know.
I'm ready to go.
If they don't today, they will tomorrow. Is there anywhere else in the law where if somebody consents to an officer conducting a search, that is prohibited from, creating any evidence that could be admissible?
That becomes fruits of the poisonous tree, so to speak, I guess.
No, I'm saying, is there
If they
anywhere
legally
else?
consent,
Yeah, do
yeah.
they legally
It's a great
consent,
question.
which as I understand it from Mr. Cox is now, I didn't know this was in here either, Mr. Cox, so don't know when that language got included, but I'm just asking, are there any other laws that you're aware of anyway that ban a consensual search, the evidence?
There are none,
Okay.
absent it being not a valid consent.
Right.
And that's why I addressed the body camera issue, so we can address that. And I know that this landed, I think on Sine Die.
Oh, yeah.
Got in there.
Yeah. And is it is unlawful to operate a motor vehicle in the state of Maryland under the influence of cannabis, smoking cannabis, however you want to respond to that question?
Oh, it absolutely is.
Right.
It's more difficult to prove than alcohol, but it absolutely is against the law.
And it's also for any substance that impairs judgment, has any kind of potential impairment of your cognitive functioning while operating a motor vehicle, large piece of equipment, that's unlawful in the state of Maryland, right?
Absolutely.
Okay. So is there any other drug or product that you're aware of in which we ban an officer's ability to investigate whether someone has consumed something, maybe under the influence on it, based on odor? I think of alcohol, for example, because that can have a pungent odor. Sometimes, even if a person is acting one way, they may smell another. Is there a prohibition for an officer who smells alcohol?
Oh, absolutely not. I mean, it would surprise me that an officer would have such a keen nose that they're going to detect the odor of beer or something as they're driving by. But if they have a valid stop, say for in that particular circumstance, that's the most common. And Senator Folden, I know, could address that. In that when you walk up to an individual who's driving a car, you get hit with that odor of alcohol, then you're going to look further.
And then it for this panel, but certainly for subsequent panels, and not for, I don't want to delay the hearing any longer, but what I would like is some data, because I didn't get any last year. I want data that shows that there was some justification, and I mean data that says all kinds of, odor cases, that were, the person wasn't consuming cannabis, the connection was not there, or in any other way that this has somehow been abused. Based on data, not anecdotal stories, which I understand anecdotes, they have a real power, stories do for sure, but real data that talks about, and I don't know if you all are aware if there've been research studies that say, this law was needed because the abuse was so rampant that we just have to accept this particular drug, unlike any other, that a law enforcement officer cannot investigate it based on.
I'm not aware of any data that would support that proposition. I don't want to step into this too deeply, but my recollection is that the concern, which I don't contest that it's a valid concern, was that police were sometimes abusing this to pull over Black and brown people.
I understand that.
Right.
And what I don't know is whether there was any data. I absolutely understand the power of stories, personal experiences, and the like. I really do. But really, I just never saw any data. I don't know whether it was the stories just related to Black and brown people, if it related, there's stories about other minority groups, but I just never saw anything. And the reason I asked you is I assume that sometimes you come across things that may not help your position in life, but you're certainly aware of them. And in your reading, you just haven't seen anybody do a real study on this.
I have absolutely seen nothing of that nature. And I guess probably getting to the basis or the original basis of your question. And as Senator Sidner pointed out, I think that odor of marijuana has become quite known to people and is unique.
Yeah, it is. All right, thank you, because I would love to get real data. And thank you all for giving me what you know. Appreciate it.
Sure.
Thank you.
Thank you so much. Senator Charles is next.
Thank you, Mr. Chair. So this is a kind of piggybacking off of Senator Sidnor's question in terms of driving down the street, smell comes out of nowhere. It's a bunch of cars out there. You don't know what car the smell is coming from. And this is all based off of odor. And so, like, I smoke cigars, or some days if I don't smoke a cigar and I'm hanging with a friend who does, and I leave my coat in the room, my coat smells just like cigars the next day. Now, mind you, 24 hours has gone by and haven't even smoked a cigar myself, but I was in the room when the cigar smoke actually got all over my coat. Same thing goes for marijuana. It has a lingering odor that lasts for some time when people are smoking. And so what happens in a situation like this where you didn't know the vehicle and they say, well, this person was smoking, but that person wasn't at the actual car that had smoke coming out, but they have this lingering odor because maybe they smoked the day before or they smoked that day or whatever the case may be. What do you do in that particular instance with this law if this becomes something that we vote on?
Well, the legislation right now is that you couldn't have even stopped that car.
So this is once if we were to pass this law, what do you do in that particular situation?
And I guess I don't know if Ms. Williamson wants to try to address it.
Are you suggesting someone has smoked marijuana outside of their car and now their jacket's in the car and smells like marijuana?
And their jacket smells like marijuana. They're in the car because the big part of this is somebody being in a motor vehicle with the odor of burnt or unburnt cannabis. So the odor is lingering all over their clothes. Now, they may not have smoked that day.
So this is someone who hasn't smoked, but has been around with someone who has smoked.
Right. And now your vehicle can be searched, correct?
Well,
Under
first
this
an officer
provision.
would have to smell it
Which now
with
they
them
do.
driving by. That's the first thing. So that odor would have to be strong enough that a police officer driving down the road smells it. The second scenario would be the car is stopped for some other reason, speed, stop sign, whatever, and then the officer smells it. And then, yes, there could be a search. But I don't know if they'd be able to stop someone if they'd be able to detect the odor just from a jacket from a day ago in a vehicle next to someone smoking. That's attenuated.
Yeah, I'm just wondering, it's
So the cases that, if you like an example, the cases that I've seen, police officer driving down the road, they say the strong odor of marijuana. They drive down the road, they're able to isolate the particular vehicle. They say there's no other vehicle in the area. I drove behind this vehicle for a certain amount of time, and then the stop is made. Because I know one of the concerns was, well, what if, you're in traffic and there's this general smell? Well, you can't just randomly pull people over. The police officer has to do their job, detect the particular vehicle, pull the vehicle over, be able to articulate it in a police report, and then in court, be able to tell a judge why they stopped that particular vehicle.
Okay, thank you.
Thank you. Any other questions from the committee? All right, seeing no questions, that concludes the proponent portion of this bill. We'll now move to the opponents of Senate Bill 396. In person, we have Joanna Silver, Karen D. Kaplan, Davon Love, Yannette Emmanuel. And as folks are coming up, we're now well into our third hour of this. We still have to vote today. The judges have asked that we accelerate the protection bill. We've made a promise to them that we would do so and that would be the first bill that we pass. So I'm going to keep everyone to their 2 minutes to honor the judges' wishes here.
Good afternoon, Chair, members of the committee. For the record, my name is Yannette Emmanuel, Public Policy Director for the ACLU of Maryland, here in opposition to SB 396. First, I would like to thank this committee for passing HB 1071 last year, which prohibited police from conducting warrantless stops and searches solely based on the alleged odor of a now legal substance, which is marijuana. The proponents of SB 396 have said that banning odor stops and searches will impede law enforcement's ability to investigate incidents of impaired driving, but that's simply not true. The law makes it explicit that the odor of marijuana can be considered as part of the totality of circumstances to support the officer's observations of suspected impairment. The odor of marijuana simply cannot be the sole basis for a stop to investigate driving under the influence. The reason why is that the odor of marijuana alone does not indicate that someone is an impaired driver. Opponents of the law have also said that the law must be repealed because law enforcement rely on cannabis odor as a justification for searching vehicles and seizing guns. That is simply ridiculous because the simple odor of marijuana does not indicate whether or not someone is in possession of a legal firearm. But what police do is use the alleged odor of marijuana to justify racial profiling. Police and state's attorneys have no real data to support their claim. We know this because we've made several Maryland public information requests for their alleged data on gun seizures obtained through odor searches. And of those who have responded so far have reported that they do not track this data. Lastly, public safety is the utmost importance for all of our communities, but diligent law enforcement can and should be used, diligent law enforcement can and should be used to solve crime using honest-based initiatives and techniques without relying on pretextual bases such as the odor of marijuana for stopping and searching Black and brown people. And so for those reasons mentioned, we urge an unfavorable report on SB 396. Thank you.
Good afternoon. My name is Joanna Silver. I live in Montgomery County, and I'm testifying on behalf of the Silver Spring Justice Coalition in opposition to SB 396. Last year, this committee heard extensive testimony from many members of the community, including SSJC, in support of a prohibition on odor-based stops and searches with a strong exclusionary rule included in the body of the statute. Hearing no opposition to the bill except from law enforcement and prosecutors, you did the right thing and passed HB 1071, recognizing that this was a critical racial justice reform because it is Black and brown community members who suffer the brunt of this invasive and often dehumanizing practice. We've heard a lot about data from Montgomery County so far today, and I'd like to remind you of some data I shared from Montgomery County when I testified last year and share some updates. Where I live in Montgomery County from 2018 to 2022, when Black people were only 18% of our population, they were subject to 31% of all traffic stops and 43% of all searches conducted during a traffic stop. I also testified last year about the human cost of these interactions. In 2021, Black people were the targets of 54% of all use of force incidents in Montgomery County. That number rose to 59% in 2022. There is no excuse to subject so many members of our community to such a significant risk of harm because an officer claims to smell a substance that is now legal in the state of Maryland. As I also explained last year, the need to get firearms off our streets is not an excuse, not when you consider how infrequently firearms are seized during traffic stops. In 2022, 172 guns were seized during 35,000 traffic stops in Montgomery County. That's less than 1/2 of 1% of all traffic stops resulting in gun seizures. and data from around the country reflects similar numbers. For example, a recent analysis of the 8 largest police departments in California found that officers confiscate firearms in an average of 0.5% of searches conducted during vehicle stops.
Thank you,
For
Ms.
these
Silver.
reasons, we urge an unfavorable report.
Thank you very much, Chair and members of the Judicial Proceedings Committee. My name is Karen Kaplan, and I am a resident of District 18 in Silver Spring. On behalf of Jews United for Justice, I am speaking in opposition to SB 0396. JUFJ organizes 6,000 Jewish Marylanders and allies from across the state in support of social, racial, and economic justice campaigns. I'll begin, as we always do, with Jewish tradition, which makes it clear that we are obligated to respond when our core values are threatened, including the concept of Tselem Elohim, the idea that all people are created in the divine image and therefore are equally precious and worthy. The action that the legislature took last year when it prohibited police officers from stopping and searching individuals without a search warrant merely because they claimed to detect the odor of cannabis was a step towards realizing this core value. Now, as then, it surely makes no sense for the odor associated with the use of a legal substance to be a gateway to entanglement with the police and the legal system. Crucially, this is a problem of equity because we know that Black and Brown people are disproportionately stopped by police both nationwide and in our state. We should be very clear that there is no way for an officer to prove a smell. And of course, there's no way to disprove a smell either, leaving the door to discriminatory pretextual stops wide open and leaving people of color significantly more likely to be harmed by police, something that happens far too often, especially during traffic stops. Under the current legislation, driving while under the influence of cannabis remains illegal, and police officers can investigate this while still respecting the rights of individuals. With this assured, there should be no reason not to protect Black and Brown Marylanders from violence, from unnecessary police interactions, and from legal entanglement in a system that data makes clear is weighted against them. On behalf of Jews United for Justice, thank you so much for the opportunity to share our position. We respectfully urge an unfavorable report.
Thank you so much. Mr. Love.
All right, good afternoon. Davon Love, Director of Public Policy, Leaders of a Beautiful Struggle. I won't reiterate what some of the other panelists mentioned in terms of the disparities as it relates to traffic stops when it comes to Black people in Maryland and really across the country. I want to focus on the fact that the law enforcement establishment in the state is used to having control over the policies of this committee and the committee across the street. And that over the past and the underlying logic of that control was around the war on drugs as the primary logic around the public safety. And so over the past, several years, my organization, those represented up here and many others, and the community has pushed for a move away from the perspective on public safety, where there is a police-centric approach that criminalizes mere proximity to things that are perceived as a part of violent crime. So whether we're talking about the repeal of the LEOBR, whether it's the changes to the Maryland Public Information Act that makes investigatory records of law enforcement available to the public, whether it's the legalization of recreational cannabis and the odor bill that this bill is a response to, whether it's the recent juvenile justice laws, reforms that are under much discussion recently, this demonstrates a move away from an approach to public safety that I mentioned earlier. And one of the things that I think it's really important for this committee to understand is that widening the net, criminalizing behavior that is understood to be proximate to violent crime, expands the net. And when we think about the way that the media has represented the issues of public safety, where the most extreme stories of brutality and criminality are put out there. And I would say for every story that there is like that, there are also several stories of people who are caught up in the criminal justice system by merely possessing a firearm because they feel that they need it for protection. People who we would agree might otherwise be better suited not to be swept up in the criminal justice system. And so what this bill does is that it expands the net to expose people to the criminal justice system in ways that can be life-altering. And the last thing I'll say is that that's not something that you see on the news. We see those sensationalized stories on the news. We don't see the stories of those whose lives are altered by encountering the criminal justice system, and this bill expands the net.
Thank you for your testimony here today. We'll now move to our virtual testimony. Ms. Holmes from the Office of the Public Defender.
Thank you, Vice Chair Walsh-Riker.
and members of the committee. My name is Tia Holmes, and I'm testifying in strong opposition to Senate Bill 396 on behalf of the Maryland Office of the Public Defender. Last year, this committee considered the issue of whether police officers should still be permitted to stop and search people in vehicles based solely on the odor of cannabis because cannabis would be legalized. Several citizens, lawyers, and civil rights organizations came and testified as to all of the reasons that this policing practice should end, and at the same time that cannabis legalization came about. A common theme in all of the testimony today and last year was that Black people have been disproportionately impacted by that method of policing. Black people were stopped more and searched more than anyone else, according to the Racial Equity Impact Note. And on the other side, as we heard today and as we heard last year, the state's attorneys and the police officers touted the number of arrests that they make and all of the evidence that they recover by using that policing method. So this law has only been in effect for 7 months and 1 day today. But this committee is considering a bill to repeal key portions of the new prohibition. Now, as I provided in my written testimony, this committee must resist that effort to return to the former law. And because everyone has said all the points that I wish to make today and that I made in my testimony, I will point out something that a prominent Maryland judge has said with regards to abuses of discretion by police officers. So if there's a lesson to be learned, it is that when the police are permitted a very broad but persistently controversial investigative prerogative, they will be well advised, even when not literally required to do so, to exercise their prerogative with restraint and moderation, lest they lose it. So last year, this committee said that enough was enough, and they took away that discretion.
Ms. Holmes, thank you for your testimony.
Thank
Question
you.
for the opposition to the bill. All right, thank you all for your testimony. That concludes the hearing on Senate Bill 396. Senator West, if you are ready, we will now take Senate Bill 389. There were some of you who weren't in the room when I indicated before, this bill has 23 witnesses and the committee is scheduled to vote today. So we ask everyone, obviously, with the exception of the senator, to keep their remarks to the 2-minute limit, please. Senator West.
Thank you, Mr. Chair. It is a pleasure, indeed a pleasure, to present Senate Bill 389, which is a significant bill. I'm going to speak at some length about the bill, and hopefully the witnesses will therefore not have to repeat what I say. So I hope everybody listens to what I say and avoid repetition, needless repetition. So members of this committee who were here in 2021 may recall the Juvenile Restoration Act, which was introduced by me 3 years ago. The JRA enabled youths under 18 years of age convicted of serious crimes in adult court who have served at least 20 years in prison to go back to the court that sentenced them and to present a case that A, they're no longer a threat to society, and B, the interests of justice would be served by reducing or even eliminating the rest of their sentences. That bill passed by lopsided majorities on the floors of both houses, and then both houses overrode Governor Hogan's veto by similar majorities. I said at the time that the Juvenile Restoration Act was not some sort of get out of jail free card. I predicted that many would apply for a reduction in their sentences, but that the courts would faithfully apply the tough standards set forth in the legislation, and therefore the comparatively few prisoners would be released. That turned out to be the case. At the end of the first year after the JRA went into effect, courts had decided only 36 motions for sentence reduction by prisoners who committed youthful crimes, and only 23 prisoners were released from confinement. None of the released prisoners had reoffended. Senate Bill 389 is the logical follow-on to the JRA. You might call it the Seniors Restoration Act because it bookends the JRA. This bill only applies to prisoners who are at least 60 years old and have been imprisoned for at least 20 years. The bill enables qualifying prisoners to return to the court which sentenced them and apply for a reduction or even elimination of the remainder of their sentences. As in the case of the JRA, if the court has not conducted a hearing on such a request in the past 5 years, the bill requires the court to conduct a hearing at which a prisoner may introduce evidence in support of his case, and the state's attorney may introduce evidence in opposition. Any victims will receive notice of the hearing. The bill requires the court to address a long list of factors, including the prisoner's age, the nature of the offense, the compliance of the prisoner with the rules of the correctional institution where he's been confined, whether the prisoner has ever completed an educational or vocational program, et cetera, et cetera, et cetera. A very long list of factors the courts are required to consider in making their determination. After considering all of the factors, this bill authorizes the court to reduce the prisoner's sentence, perhaps eliminate the remainder of the sentence, provided the court makes the determination that A, the prisoner is no longer a danger to the public, and B, the interests of justice will be better served by a reduced sentence. In other words, the same standards of the JRA. Once again, this bill is not a get out of jail free card. The criteria for a sentence reduction are tough. Let me explain why I feel passage of this bill is warranted. First, the most recent numbers available to me show that in July 2022, nearly 15,000 people were imprisoned in Maryland prisons. Of the prison population, 1,105 prisoners were over 60 years old. So that's the upper estimate of prisoners who could take advantage of this bill if it were to be passed. Of course, many of those elderly prisoners would not qualify under the bill because they have not been in jail for nearly 20 years or for over 20 years. Secondly, the cost to state taxpayers of keeping someone incarcerated has been given various estimates. I've seen estimates as low as $39,000 and as high as $60,000. The total cost of keeping all of those elderly prisoners behind bar, therefore, is in the range of $50 to $60 million a year. Furthermore, since the state's responsible for paying for the healthcare expenses of its prisoners, the actual cost of keeping elderly prisoners behind bars and dealing with their health issues is likely considerably in excess of $60 million a year. Thirdly, decades of research tells us that as people age, they are less and less likely to commit crimes. There's a reason why corrections officials often characterize persons over 55 years of age as elderly or geriatric. This is because the health of elderly prisoners who have spent decades behind bars is not as robust as people who have not spent much of their lives in prison. The Prison Policy Initiative has produced research showing that every year in prison takes 2 years off a person's life expectancy. A 2018 study found that incarcerated individuals with an average age of 59 experienced the following 4 geriatric conditions: mobility impairment, hearing impairment, functional impairment, and incontinence at rates similar to those found in non-incarcerated persons 75 years older or older. For the other 2 geriatric conditions, falls and multimorbidity, the study found that the prisoners with an average age of 59 experienced at rates similar to those found in non-incarcerated persons between 65 and 69 years old. And the Johns Hopkins Bloomberg School of Public Health released a study last year showing that for many common and serious conditions, incarcerated people are substantially less likely to be treated compared to the general US population. So elderly prisoners are far less healthy than their non-incarcerated contemporaries. And not to belabor the point, elderly, unhealthy people are simply not serious crime risks. Recidivism statistics for people in this category are nearly non-existent. As a result of these statistics, it's possible that many prisoners who are over 60 years old will be able to make a strong case that they are no longer a danger to the public. But there is still that second factor that Senate Bill 389 requires the judge to consider, and that is whether the interest of justice would be better served by a reduced sentence. Certainly, there are some prisoners whose crime was so heinous and betrayed such a lack of any sense of morality that those prisoners should not ever be released from prison. Senate Bill 389 recognizes this, as it explicitly requires the court to consider the nature of the offense. But after conversations with Senator James in particular, I believe that the courts need a little more direction in this regard. So I've had an amendment to the bill prepared. I haven't seen it in the packets. I'm not sure it's back yet. It adds to the bill the requirement that a court considering one of these cases should take special note of the sentence handed down at the conclusion of the trial. For example, if a prisoner was sentenced to the stiffest sentence possible under current Maryland law, life imprisonment without the possibility of parole, that fact should weigh as the court considers whether the interests of justice would be served by a reduced sentence in that particular case. In short, just as there are overwhelming reasons why juveniles sentenced to jail for lengthy periods should be able, after 20 years, to ask a court to consider whether they are any longer a threat to society and whether the interests of justice would be served by reducing their crimes, their sentences, so are there overwhelming reasons why elderly, frequently infirm prisoners who have served over 20 years in prison should be given the right to appear before the court which sentenced them in the first place and ask the court to consider whether they're any longer a threat to society and whether the interest of justice would be served by reducing their sentences. With those comments, I appreciate the court's consideration of this bill. I hope for a favorable report, and I'll be happy to answer any questions the committee may have, either now or after some of the witnesses testify.
So do you have a sponsor panel that you'd like to bring up, or is?
I didn't have any particular sponsor panel. I know there are lots of people who want to testify in favor. I think I counted them as 26.
Excellent. No, if there's no sponsor panel, then we'll take questions now of you, the sponsor, and then we'll move on to the rest of the witnesses. Senator Muse.
Thank you very much, Mr. Chairman. Thank you very much for putting in this bill. I was somewhat amazed at the cost of $60 million a year.
To keep people in jail who are over 60.
And I think of what we could do with $60 million to prevent juveniles from being in this same place years from now. And so the cost of this alone, does this include medical, et cetera, et cetera?
Well, I don't know exactly. The estimates of the people who were be eligible for release vary. And the estimates of the cost of keeping someone in jail vary. I've not gotten any definitive information on that. It's between $39,000 and $60,000 per year per prisoner. And when you factor in that elderly prisoners tend to be unhealthy and need much more medical care than younger prisoners, you have to add that into the equation. If you put it all together, you're talking about something in excess of $60 million a year to care for prisoners over 60 years old in our prisons.
Thank you very much. And the only thing I don't see is my name on your bill, so I hope you'll amend it on.
At the time we vote, we will all have an opportunity to add our names to the bill.
Thank you very much, and thank you, Mr. Chairman.
Thank you. Other questions?
All right. See no further questions. Thank you very much, Senator.
Thank you.
All right. Thanks. We'll move on to the panelists. Mr. Dent.
Good.
Ralph Martin and Jane Harmon. Is Harmon here? Jane Harmon.
Yeah,
oh, you all of you all can come on up. Yeah.
It's brand new.
Hey, no worries. No. Take your time. And is Jane Harmon here? Shakina Braveheart.
I'm at Dave.
Come on up, ma'am. And then we'll do James Grayson.
Mr. Harmon, Mr. Harmon went to the rest.
Yeah. Okay, thank you very much. I'll make sure we get her. We'll get Jane when she gets back. And all right. Sir, your floor is yours. Welcome.
I'm Ralph Mateen. I went to prison when I was 28. I was released when I was 70. When he was talking about the medical issues, I've had so many operations, 2 operations on my spine, colon, hypertension, and numerous things. The medical care that we receive in prison is subpar. Geriatrics, We suffered. I was paroled in 2022 after serving 41 years. Every opportunity I had in prison to improve upon myself, I took advantage of. Two bachelor's degree in psychology, one in criminal justice. Everybody needs a second chance. We've shown that, you know, I work now in a behavioral health program. I work for time. So the returning citizens that come in back into society, we're there to assist them. Because of our experiences, we are better equipped to deal with people coming back in and guide them to make sure that their transition back into society is a smooth one. But like I said, everybody that deserves and has shown that he has changed his behavior needs a second chance. I don't even have health care right now. I was forced to work on work release. The medical system said that you don't qualify. I need health care now, can't get it. So these are some of the issues that we have returning back into society, but nobody's trying to address it. But we just need help.
Whoever would like to go next.
Good afternoon. My name is Gerald Dent, born, bred, and raised in Baltimore City. I'm retired from corrections. I spent 40 years in every institution in the state of Maryland. And for the last 10 of those years, I was on death watch. I mental and I sat with the brothers that was passing away, many who had no family left. And the one thing to the man before they left this world, they all were so remorseful. And then none of this, I might say today that for every day that I've been out, I remember the impact of the victim and the ramification of that. So many people are victimized every time we commit a crime. But every one of them men that left this world, they were so hurt and downhearted because they didn't have an opportunity for redemption. They didn't want the last thing on their legacy be they killed somebody. They want the opportunity to go out there and show that they can do some good as well as the bad they done in this lifetime. And every time I'm before a committee like this, we think every day about the victims. I grant you, I stayed in jail 40 years, and I too will say I met a couple individuals I don't think should never be free. And I thought I would never say that. But there's so many men, the ones that died, they got the degrees. That's before somebody in the infinite wisdom said that there's no need to let these guys go to college. They never getting out. So they snatched the college program from the system. But every one of them could have made a great impact because there was people's persons. I myself, 4 years social science, which I call it people's degree. My first week home, I'm down Murphy home in the chaos of the Freddie Gray demonstration.
Mr. Dent.
I'm down there doing my best to try to cool them, be chill. You know what I mean? I'm saying carbon copy, this crazy energy that I see out here that I experienced when I was a child.
Thank you, Mr. Dent.
I hadn't seen a protest or a riot I didn't like. But the time I got free, I had a whole different understanding about life in general. Sure wish I had all day.
That's all right.
Take your mask off.
Chairman of the board, hello. My name is James W. Grayson. I'm here to support this bill dealing with second chances. Why am I saying this? It's because of a case that happened in 1951. When my father died in an electric chair, along with 6 more men, they deserved a second chance. But because of this, when I went to court, the court said, like father, like son. I wound up with life in 15 years. I was just released in 2013. So I believe that anybody who have went through the process of what I went through deserve a second chance. The second chance would really change their life and give them a chance to be prosperous in society itself, that they may reach out to other people and help them not to come or do the things that they did. So again, I thank God again for his mercy and for his grace to allow me to stand here before you today. I believe in second chances. I would want anybody to have a second chance. All the men behind me have been through things that maybe none of you could ever go through. But again, with God, with his mercy and his grace, he allowed me to be here. I'm a minister. I'm one that when I went to prison, I had hatred, I had envy, I had strife, everything in my heart. Why? Because I didn't understand why 7 men would be executed. But after 70 years, they were actually, one would say exonerated, and meaning, praise God, that they received a posthumous pardon after 70 years. But the families of the 7, or the 6 families received nothing. That's why I stand here today, and I am in support of second chances. Thank you.
Thank you so much.
Good afternoon, everyone. I'm Shekina Braveheart with the Justice Policy Institute. SB 389 offers seniors who have demonstrated the capacity for positive transformation an opportunity for review and reduction of sentence. It's not an attempt to minimize the negative impacts of crime or shirk responsibility or disregard the suffering of victims. The growth of the U.S. population, prison population, has been driven not by more crime, but by policies that send more people to prison and keep them there for longer periods of time. One consequence of this trend, of course, is a large and increasing number of incarcerated elder individuals. In Maryland, 3,324 individuals are over 50. Unsurprisingly, they are overwhelmingly Black. A 2019 JPI report found that 8 in 10 people who were serving the longest prison terms in Maryland are Black. And of that population serving those terms, 41% are Black men who were sentenced to prison as emerging adults, that is under the age of 25. This suggests that the aging of the prison population will not slow down. The Justice Reinvestment Act of 2016 lowered the geriatric threshold from 65 to 60, yet current policy excludes most from submitting a geriatric parole petition. And as for regular parole, those who are least likely to reoffend are most likely to be denied. Research has conclusively shown that by age 50, most people have outlived the years in which they're most likely to commit crimes. Arrest rates drop to just over 2% at age 50 and are almost 0% at 65. Maryland's Unger cohort is 5 times more likely to pass away from old age than to recidivate from a new crime. And many of them are gentlemen who are right here today. Other states have had similar experiences. New York reported a 7% reconviction rate from those 50 to 64. Okay, oh, my time's up. All right, so in short, after 60, we see deep declines in reoffending and a precipitous rise in expense. The crisis of mass incarceration in this state is not the result of one failed policy, but many, and it will take a multifaceted approach to begin to repair the damage. For this, I ask you to please issue a favorable report.
Thank you
on
for your
SB
testimony.
389. Thanks.
Do we have any questions for any of these panelists? Senator Carter.
Thank you for your testimony and thank you for being here. This is our second day of hearing this type of bill about second chances. No, Ms. Braveheart, you recited in your testimony just now that the data shows, I think you used the bright line of 50, that people over 50 are less likely to recidivate. But this bill is a boundary of people over 60. Is that correct?
That is correct. That it's people over, there are 3,324 people who are over 50 in Maryland. But yes, after 50, it declines, but it gets even lower. The likelihood of recidivating gets lower as people age. So 50, it's low, 60, it gets lower, 65, it's like almost zero. So yes.
I understand. Thank you.
You're welcome.
Senator Muse, followed by Senator Fulton.
Thank you very much. So any of the panelists, especially those who were incarcerated, particularly those who were incarcerated who testified already. To any of you, I'm going to ask a couple of questions, and whoever wants to answer can answer. You said that you worked in any one of you. Yes, okay, thank you. He's been designated. Anyone you mentioned that you had jobs in prison. Obviously, they gave you something to do in prison. Was that considered something you had to do every day? A work program? What was that?
I worked in American Record Enterprises, and it's a power program. I worked for private industry. From 2005 to 2015, I was allowed to pay federal and state income taxes. But on the downside of that, they didn't take out Social Security. So as I'm 70 years old, get ready to turn 71, I don't qualify.
So when you were incarcerated, you had quote unquote medical insurance. But once you were released, you had no medical insurance.
No whatsoever.
Did you get anything back from the state for all that you paid in for all those years?
They're saying because I didn't pay into Social Security for those 10 years that I worked and paid federal and state income taxes, that I don't qualify. I didn't have no quarters.
So maybe next year a bill to look at would be some kind of medical.
It told me that I would have to work another 4 years in order to earn 16 points or 16 quarters.
What'd you do the rest of the years you were there? What did you do the rest of the years other than that 14 years? Did you work anywhere else in the system?
I worked in the tag shop.
Okay.
I was on a college program from 1983 to 1989. I tutored. I worked as much as I could. In 2015, I had another operation on my back, so I no longer work in the shop. But I got another job in a tag shop where it wasn't that strenuous. But overall, even with parole, I was forced to work. I worked on a road crew. I couldn't walk, miles and miles and miles. So they took me off of that job and gave me a job in central booking. There, I had to go to work release. I went down Dorsey Run. I got a job working at Dunkin' Donuts. Thus, when I was paroled, I still had maintained a job. I got to work because couldn't get social service. Everything I tried to get, they denied me.
Okay.
So
you worked in that system all of those years. I'm sure it benefited somebody who didn't have to pay you the salary that you would have been paid if you were out and all the benefits. And after all of that, you were released.
I was released in April last year.
Did the state provide anything at all to live off?
They gave me food stamps for about 2 months, then they cut them off because they said I was living in Howard County, so they was paying $15 an hour. So they say I made too much. I got to pay car insurance, life insurance, buy food, pay rent, and no money for healthcare.
Thank you all for giving me an idea on what I'm going to work on during the interim and some bills that I'll put in next year. Thank you very much.
Absolutely. Mr. Martin?
Mr. Martin,
do you happen to know who your state senator is? If not, we can figure that out, but we'll make sure to connect you to your senator. In between now and possible legislation, we want to make sure you get the services.
In contact with Ms. Shelley Hellerman and Congressman Weiss and Fulmer trying to get health care. Still, I'm still struggling trying to get it.
We'll work with them. Great folks both. Senator Fulton is next.
Yeah.
So, look, I like this bill. I told my good friend here that I like this bill. I do have a couple questions though, and whoever wants to answer it, please help yourself to it. So I don't want to assume anything. What I want to know is if you're serving the terms that I'm hearing most of you men coming up and talking about,
Yeah.
you were involved in, I'm gonna estimate a first or a second degree homicide. Is that a fair assessment
Yes.
on those amounts?
Yes.
I was convicted of being a suspect in murder, but not the one who carried a gun. No co-defendant. I served for.
No code. You were the co-defendant or?
I didn't have any co-defendant.
Oh, I see. Okay. All right. Okay. So I'm just curious to hear those circumstances around, like with yours, sir, being in 41 years. Because with those sentences I'm hearing, that it made me think to that. And then I wanted to know that at what point was everyone like life without parole sentencing, or was there just a maximum sentence imposed and you were eligible for parole? You were going to parole and you were just getting parole denied?
Yeah.
Is that fair?
That's exactly what was.
Okay.
That's exactly what occurred.
And in those instances, what was the term when you were eligible to start having parole hearings? Do you remember? Like how long you were?
It was 15 years.
15? Okay.
Yeah, it was 15 years.
Okay.
I went to prison when I was 17. I received a life sentence for first degree murder.
Okay.
I stayed locked up for 37 years. I come home when I was 54.
Right.
And I went up for parole. They gave me a 4-year rehab. Then I got transferred. Then they gave me a 2-year rehab. And I was on my way to pre-release at camp when Glenn Denny shut it down, say life means life. And I did an extra 30 years. Yeah.
Okay. Thank you for that. So that kind of, I'm glad you said that, because what I was hearing is a lot of the speakers coming up were saying that they were like 70, coming up around 70. I mean, yours was 54.
I got released when I was 69.
69, right around 70.
Yeah. 69.
Okay. The only thing I would ask is, and we don't have to discuss it now, is, and I would love to talk on a sidebar, but I hear a lot of good discussion about, you know, getting yourselves back in touch with the community that you left, trying to make it better. The dialogue that you're trying to impart on some of the younger members, especially with the surge in gun violence we're hearing or we're seeing.
Yeah.
And sir, yours is altogether kind of unique from what I'm gonna say, but the victims don't get a second chance. So that's the only thing I would love to have a discussion about. Like when you're coming forward, these programs that you're involved in, what rises to the level that as a society is the family that's of the deceased gone? Have they all died? Have they passed away? Or is there something that through these programs you're involved in prison? And I'm asking very ignorant here. This isn't a angled question. I just want to know, you know, the victims are not getting a second chance. And at what point do we decide that, okay, we're ready, we need these guys to come back into society and start quelling with another angle of this surge in violence we're seeing?
Well, I'm gonna tell you a little bit about myself. That's
Yes, sir.
all I know about.
Yes, sir.
I was 17. I made a mistake, and a man lost his life. Now, I went to prison as a young man, and you know, when you're young, you're still wild and everything.
Oh yeah.
But for me, I was in the Maryland State Penitentiary on lockup when my father passed away.
Yep.
And I was sitting in the cell crying, and then it dawned on me that I have another family feeling the same way that I'm feeling now. And at that point, that's when I decided to change my life. Because I realized that I hurt somebody else's family. I hurt their family and I hurt my family by taking me away from my family.
Is that when you started getting in programs?
That's when that's when I went to school, got my GED, went to college, started helping with the program. We did create juvenile counseling programs inside the institutions that's still relevant today inside the institutions.
No, that's what I wanted to hear. So I don't want to hold this hearing up any longer. But I honestly, Your stories are important.
Yeah, but
And
we
for-
come back out here to try to make amends for the victims and everybody else, because if I could save 2 or 3 of these juveniles today,
Yes,
I feel as though I made an impact
yes.
on the world.
I'd love to continue the dialogue off screen, but I appreciate that candor. That's what I'm trying to find out. I want to hear those things that are coming back around during this reintegration process, because your reintegration, albeit yours is a problem with the healthcare stuff, is important.
Thank you.
Thank you.
I think
And
that's
just for information, our motto is failure is not an option.
I like that.
all right. Thank you. We do have to make sure everyone here has the opportunity to testify. So I'm going to move on to Mr. Timmons, Mr. Winstead. Oh, I'm sorry. Senator Carter, I didn't see your light on.
Question, but there could be other people that I could ask it of, because my question could potentially be asked of just about anyone that's coming out, that's been incarcerated for a long period of time. Because
why don't we grab their testimony and then circle back?
Well,
it's up to you.
Could I, the gentleman that was just up here before, and then here's my question. So if you could come back for a second, I'll ask you the question of you, and anybody else, if you want to throw in like a 2-second response to this same question after your testimony, I'd appreciate it. So, you testified, you were a certain age when you came out, and some of the debate that we're talking about is we want people to have been rehabilitated. My question to you and anyone else that chooses to answer the question is there a bright line age? Because according to you, I don't know how old were you? You went in at 17. What age were you when your father died and when you changed your life?
26.
Okay. So my question is, had you been released prior to when you were released, say after serving 20 years, 25 years, would you have been in the same frame of mind as you were at the age you were released in terms of not likely to recidivate?
Yes.
Is there a bright line age that we should look at, or is it the person
It's
and
the
their
individual,
circumstances?
because if you serve 20 years or more, it shouldn't be an age stipulation on it. The elderly should get the first option to be released if this is passed. So I think that it's the individual, and you look at the individual progress, his education, his accomplishments and things of that nature. So you can't put an age limit on when a person mature or develop more.
Would you agree that, so in your case, had you been released or considered for release after 20 years, you went in at 17, you would have been 37, 38. So let's say you had an opportunity to be released at that age. Would you have been prepared?
Yes, I would. Because one of our things was in the prison was prepare yourself. Because when preparation meets opportunity, you have success.
Was there any benefit to having you serve a longer sentence aside from the consideration of the victim?
No, I don't think it would have been any more for me to serve a longer sentence, because you only could deal with the individual to find out if he's ready for society. And you got some that's ready 45, 35, 55 years old. I don't think you should have to wait till you're 60 to get the benefits if you deserved it, if you earned it.
Okay, thank you.
Okay.
Anybody else that wants to weigh on that issue, we'd appreciate it.
I want to try to do one question, one answer, just to make sure we are able to get through the day. Okay, so Mr. Timmons, Mr. Winstead,
Mr. Winstead.
Okay, Ms.
Good
Meadows,
afternoon.
let me just grab everyone up here so that we can have panel turnover that's efficient. Mr.
Douglas Winstead.
Yes, no, I know, we got you. Give me 1 second here. Is Stanley Mitchell here? Come on up, please. Mr. Sacenti? Is Mr. Sacenti here? Come on up. All right, Mr. Winstead, the floor is
Good
yours.
afternoon, Mr. Chairman and members of the committee. My name is Douglas Winstead. I am the first UNGA release in Baltimore County. You did ask a very important question, Senator. Not everyone's incarcerated in Maryland for first degree or second degree murder. I was one of 3 co-defendants in a burglary, robbery, rape case in 1979, received a life sentence. I was also in the United States Air Force at the time. I was a high school graduate, and I took advantage of my opportunities while I was incarcerated. I was also one of the 50 members that Governor O'Malley denied parole to in one stroke in 2007. So I'm also now a short haul truck driver and been there for 7 years. I've been paying taxes and I've been law abiding. And I had prepared myself many years prior to my release to transition to society. And since then, we've been in a situation where we have the governor taking out a parole process now, and we have a backlog of individuals who do not have a second chance because it'll take probably 10 years of corrective action just to make up for the backlog between Governor Glendenny, O'Malley, I believe Ehrlich was in there for a minute, and Hogan. So these successful transitions don't have to wait. I was 55 when I got out. From 18 to 55, I was 36 years and 10 months as a principal in the first degree, as I said, in a burglary, robbery, rape case. And I didn't have a second chance. I had an entire incarcerated period without an infraction, 36 years and 10 months. And I still couldn't get out of the system until the Younger decision. I made the Younger decision by 19 days. So I work hard now to not only be a law-abiding citizen, but to support this legislation because I believe it's a favorable result, and I believe I'm an example of that. Thank you.
Thank you, Mr. Winstead.
How y'all doing? My name is Ralph Timmons. I went to jail when I was 18. I came home when I was 56. Well, going on 56. I was a month away from my 56th birthday. And I didn't understand fully what I'd done when I went in at 18. But 3 years later, after I was incarcerated, I had a sister to get killed. She got stabbed over 22 times. And like Mr. Kareem Hassan just said, that's when I realized how my victim's family felt when I took their loved one away from them. And then I realized that I had to make a change within my life while I was there. Now, when I went in, my reading wasn't that well, but while I was there, I improved it. You understand? And I got involved with a lot of programs. Now, when I came home, I ran into a couple of my victims' kids. And one asked me one day, why did you take my parent away from me? And I told him I was sorry, that it was a mistake. I was young. I was trying to make a name for myself. I said, we do stupid things when we are young. I said, I can't bring your parent back. But if you ever need me to help you with anything, I would try my best to do it. I can't work no miracles, but I will assist you however I can. Now, since I've been home, I have a lot of nephews. I done saved 3 of them from the street. They was out there on the corner. And I sit down and explain to them my experience of my incarceration. And I honestly told them, look, I went in there when I was 18. I was 55 when I came home. You don't want to follow my footsteps. Because some guys have done lost all their loved ones while they was in there. They don't have nobody when they come home. Nobody. I was lucky to have mine when I came. So I feel those guys that's in there should get another chance.
Thank you for your testimony. Whomever would like to go next.
Good afternoon. My name is Stanley Mitchell. God willing, I'll be 76 in July. I was released at 65 in June 20th, 2013. This is about my 9th year coming down here on various bills to try to open the doors for individuals I left behind. As you've heard, that most of us that have returned to society, we have health issues and other things, but we still try to give back to the community to help the victims and people that we may have harmed. The reason I'm supporting 389 because it's personal to me because I was an older prisoner. And we're talking about death. I'm tired of going to funerals of individuals that I left behind. I'm tired of seeing individuals that come out, they were doing good and helping out in the community, and they just dropped dead. So I really strongly support this bill because of that. That's why I strongly support something that has an age limit, and I think that the elderly inmates should get priority because of that reason. I'm tired of seeing death. But any bill that will, I believe, as my grandmother told me, to make a pie, you need sugar, flour, and yeast. Taking the government out the process might have been the sugar. We need this bill and other bills to provide a sheet, excuse me, I'm a little nervous because this is personal to me. The supply, the flour, and the yeast. So because it didn't take one item to get us in this situation, it's going to take a lot of items to get us out. And as I said, most of us that are physically capable are trying to do the right things in the community. Thank you.
Good afternoon. I'm Brian Ciceni with the Maryland Office of the Public Defender. We ask that you issue a favorable report on Senate Bill 389. This bill allows people 60 and older who have served at least 20 years to seek a reduction of their term of incarceration. There are no other adequate vehicles for courts to review the sentences of older individuals after a substantial amount of time has passed. I've represented people who have been released after Unger and through second look provisions in the Justice Reinvestment Act and the Juvenile Restoration Act. Most of those released were Black men between ages 40 and 70, which shows how second look can help to remedy the racial disparity in Maryland's prisons. I've been truly inspired by the way they've become forces for good in their communities, supporting their families, doing conflict resolution work, and most of all, mentoring young people. About a year ago, I had helped a man named John, who was in his 70s, get out under the Juvenile Restoration Act. He hadn't had an infraction in decades, and he had been housed in the prison infirmary for years because of health problems. He was released by a judge and went to assisted living. A week or so before Christmas, he spent an enjoyable evening with others in the home, and that night died peacefully in his sleep. In 9 months of freedom, he got to spend time with his family and friends, sit on the porch on nice days, and listen to one of his housemates play violin in the mornings. Because a judge could release him, Mr. John got to spend the last months of his life with a measure of dignity and peace. Releasing him was the right thing to do. It was in accordance with the values of a society that believes in redemption. I wish he could have been released a lot earlier. This bill will help others like him. Thank you.
Good afternoon. My name is Lila Meadows, and I'm an assistant public defender. And for several years, I ran a legal clinic at the University of Maryland School of Law, where I had the privilege to represent long sentenced individuals in both the parole process and in Juvenile Restoration Act motions that have been referenced today. I'm happy to answer any questions about the mechanics of how a bill like this would work in court, but I'm here today in support of Senate Bill 389 because this year I had a client whose story ended a bit differently than what Brian just testified to. I had a client who unfortunately wasn't eligible for the Juvenile Restoration Act. He went into prison at 30, spent over 35 years incarcerated, and contracted COVID, which did incredible damage to his lungs. It required him to be on supplemental oxygen 24/7, and he was living in the prison infirmary. When medical parole was denied, I had to explain to him that there was nothing left to file in his case. I was out of options for him. It was a matter of time, according to his doctors, before an infection would take his life. And when that day came, his son came into my office unannounced and said to me, "Is there anything you can file, please? My dad is going to die." And the answer was there was nothing for me to file, even though his dad was over 60, even though it had been 30 years since he had an infraction. There was nothing I could do for my client, and there was nothing I could do for his son, except send an email to the warden and ask for enough mercy so that his son could be at the hospital where he was now confined and be with his father as he took his last breath, shackled to a hospital bed. I don't want to have any more of those conversations with my clients and with their family members. And so I urge you, this group is so vulnerable, please support Senate Bill 389. Thank you.
Thank you, and thank you to this panel that were in which I saw the questions were Senator Kelly and then Senator Muse. Senator Kelly.
Thank you, Mr. Chairman. My question is for Mr. Winston, if you can come back up. And while you're coming, I'll just say I am a co-sponsor of this bill. I think it's a really important legislation. I understand where it is coming from. And I really appreciate the testimony of everyone here today. I know how hard it can be to talk about your personal experiences in front of a committee like this. So thank you for your testimony. My question is related and a follow-up to Senator Folden's question earlier. But I would like to give you the opportunity, since I know it's hard to say everything in the 2 minutes you're given. I would like to give you the opportunity to demonstrate to us who want to support this bill that you have remorse and compassion for the victim of the burglary, robbery, and rape.
Well, let me say this, okay? I was 17 at the time of the crime. The other co-defendants were 18 and 19 in the case. I was under the definition of Maryland law, a principal in the first degree, aider and abetting. And in that case, what you call before and after the fact. Okay. Now, of course, all of the other intricacies that come into play in terms of the crime itself. I had taken responsibility. You don't break into somebody's home at 3 o'clock in the morning, whether you're intoxicated or what have you, and then assault a 21-year-old University of Maryland student. So I had to reconcile with that because I had 3 sisters and a mother. So, you know, I had to accept responsibility. I played an essential role in this crime, and I deserved a lengthy period of incarceration. But I did everything possible during the course of my incarceration to transition. I earned a bachelor's degree. I went to Blackstone Career Institute. I became a paralegal. And I worked on the law. I took my case all the way to the United States Supreme Court without the assistance of a lawyer. And I did everything until Glenn Denny came along and said, life means life. And even though Governor Ehrlich reviewed my case and O'Malley, my case was pending there, I just couldn't punch a hole in the system. But yes, I was there on December the 15th. The victim was there. I was able to take responsibility before her and take responsibility for the crime. But I just want to just emphasize that at some point in your life, in terms of that, you know, we can't define ourselves by the worst thing we've ever done. If we do that, all of us will be suicidal because I had to move away from this crime. That's the only way I would be able to succeed as a commercial truck driver now. I drive the highways between Delaware and Maryland today. I've been paying taxes. I make a living wage and I can dress myself and do all the other nuances of society now. But I had to forgive myself also. And I had to move forward. That's part of redemption. That's part of healing. That's part of moving forward. It can't always be about just retribution. If we're going to live that way, then we got a society that's really never going to heal. And I believe strongly in the fact that many of these men, many of them I know, have taken responsibility for their actions and they deserve a second look. And I appreciate that I received one. I didn't get it through the parole process. I got it through the court system, but that's because I won a new trial. And I went in and I pled guilty, took responsibility. I did 5 years probation and I moved on with my life.
Thank you very much.
Senator Muse.
Thank you, Mr. Chairman. Thank you. And this is a question for any of you, prefaced by this. I'm just so troubled to know of the it shouldn't be inhumanity for inhumanity. When I hear of a gentleman who is so sick, can't walk, pretty much on oxygen, dying, and still handcuffed to a bed, that too is extremely cruel. I wanted to say that. We say correctional system. We call it the correctional system. We don't call it the permanent punishment system. We say correctional. And my question that I need to have answered, and pardon my ignorance to my colleagues, is which is it? At least I need to know the difference between when one has attained correction or punishment. And so what are the goals of incarceration that we are paying $32,000 to $35,000 a year per inmate? because if we don't know what it is, how can we determine if we're making progress? If it's a correctional system, then we ought to have relook at this and restructure it. It's an antiquated old system. Two wrongs don't make a right. I understand the families and they need, justice done, but two wrongs do not make a right. How can we determine if it's correctional, then we need to reflect on what are the goals, what's the purpose, how are we reaching it, when has it been reached? Because it seems to me that any one of you at $35,000 a year, $39,000-$40,000 to be housed, could have done much more in our troubled streets as mentors under supervision than being incarcerated. So my question is, if all of you experience, you may not be able to answer, do you see it as a correctional system, as a forever until you die punishment system? Because if so, we need to rename it and redo it, restructure it, figure out our goals, and what are we getting for the money that we're putting into it?
Senator, let me just give you this response here. I don't know if you remember Bishop Robinson, former police commissioner in Baltimore City. He was also secretary of public safety and correctional services. He said something I didn't like at the time, but it was really, really, it became the light as years went on. He said, you grow your way away from criminal activity. You mature yourself out of it. So that's why I believe that was the catalyst to why Governor Schaefer did what he did. Okay, when he took everybody out of the pre-release system, he moved everybody back as a result of a murder that happened with a pre-release incident. Okay, so it's been my experience because I work now with transitioning seniors out of the system. Okay, that's what I do as part of my ministry. I'm a full-time truck driver, but I work with these guys, helping them readjust through Department of Social Services. I just had a brother that got out last Friday, 42 years in Prince George's County. He got his driver's license yesterday, but it was because we had the mechanism in place to assist him in transition. We can't get away from the fact with these long-term incarcerations that the support system for these individuals deteriorate. Okay, I was fortunate because I still had my parents. I still had my siblings. I had the military benefit that I had. So I had a transitional support system. The United States military paid for my CDL, okay? But my point is that when people mature away from crime, okay, and they transition, then those behavior patterns are very, very observatory in terms of their activity while they're incarcerated. So a lot of times you can't mask for years on years behind walls whether or not you've made a change in terms of your disposition and your attitude towards your offense. So for those who have been successful in not only adjusting and oftentimes institutionalized once they get out, man, because I just had an experience this morning at a Royal Farms and one of our brothers didn't even know how to get the coffee out of the machine, okay? So we have to transition very slowly and empathetically with this situation, but we can't close the door because it doesn't make sense to have these elderly individuals laying around in these correctional institutions at the economic expenses that it's costing to keep them in there when we can transition them back into the community and they have almost a zero recidivism rate. Now, we're talking about the logistics of money and what it costs. It seems to me that's the much more practical approach to take than dealing with having folks laying around into these prisons year after year after year when they're no longer a threat to the community anymore.
Senator, we're the only country in the world, the only country with this antiquated system, wasting money. Maybe it's time that we put a task force together, really, instead of piecemealing this, to change our goals, revamp our system in Maryland so that at least there's a model for the rest of the nation to follow. Because we keep hearing we're the only country who imprisoned this, getting our population, blah, 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 blah. We still have violence at a high level. You look at at other countries and what they do, their rates are lower, which means prison doesn't always work. And I know that, thank you, Mr. Chair, letting me have this opportunity. But I'd like to see us as legislators to sit down and really look at this from its totality with the task force that says we can do better. Other nations do it. Why can't we? Thank you all for and thank you for hearing me, and thank you for giving me the opportunity to.
Thank you, Senator Carter.
Thank you. I know you want us to rush along. I promise I won't keep talking. I'll put this question out there, and I have a comment as well. So, because several people have testified, including you, Mr. Timmons, that you were 17 at the time, you were very young at the time. Several people have said very young at the time, and you were immature, you learned. I just, want to add to that it's not, in addition to the tender age, oftentimes the life circumstances that you've had prior to that time or prior to the incident were also not conducive to a different path, meaning many people that were young at the time were also in a culture, in an environment that they couldn't control because of the fact that that's where they lived. And there was no economic engine in many neighborhoods, especially in Baltimore City, other than the illicit drug trade for a very long time. And still, so the other factors such as that culture, the other factors as such as addiction, the other factors such as en masse lead poisoning of children at that time, horrifically terrible, disparate education system, all of those factors play a part in the mentality at the time when you're young. It's not just that you're young, it's that you're young, you have other terrible stuff going on. That being said, my question is primarily directed to the public defender and Ms. Meadows, because you both spoke about your client who yours was 30 when he went in. He wasn't that young, but your client, Mr. Sensei, passed away right after, and it was nice that he had that grace and that opportunity, but would it not have been better had he been released sooner so that he could have actually had more of life left? And would that have not been better for him and not any kind of a detriment to the public safety?
Absolutely, 100%. And I know you asked both of us, so I'll just say something, maybe step aside, and perhaps Ms. Meadows can supplement what I say. But I would say that I know that, Senator, I know you have a bill, Senate Bill 123. I watched the very moving testimony yesterday in support of it. And I would wager that all of the witnesses here would also hope that this committee would pass Senate Bill 123 because it is a broader second look. It will help more deserving people who have turned their lives around. And I will say, is there a magic number? Does you hit 60 and all of a sudden, bam? Absolutely not. I just last week represented a man who is almost 43. He has done more to help young people coming into the system not come back through programs that he helped develop in the system than I could go on for way longer than we have. But he has become an absolute force for good. And I am so delighted to say he should be getting released by 3 o'clock today because the judge gave him a second chance. And so I think it's fair to say—
Can you just share what was the mechanism that was used?
It was the Juvenile Restoration Act.
Thank you.
And I would say that everyone here would say, if you can pass a broader second look, do it. If for any reason, because we know that sometimes good, important bills don't always get through as fast as they should. And I heard what you said about the unit rule yesterday, and what an example of a bill that should have been passed 20 years ago. If for any reason you can't pass 123 this year, I hope you will consider supporting this bill because it will help those who can least afford to wait.
Thank you, Mr. Sensei. Appreciate it. Okay.
Thank you. And that's sufficient, unless anybody wants to answer.
I think we do
I'm happy with that
one
answer.
person, one response. Let's move to our next panel. Mr. Hassan, Mr. Owens, Ms. Harmon, who I think was out of the room earlier, Mr. Wellington, Mr. Carver. All right, whomever would like to go first, and just to be clear, we're not rushing along. We want to hear from everyone, but our ability to hear from everyone, given that today is a voting session, is dependent on our ability to finish up this hearing in a timely fashion. So go ahead.
Hello, my name is Stephen Carver. I'm here in support of this bill because I speak for what I believe, what I call the forgotten. I was incarcerated at 19 years old. I was given a sentence of life without the possibility of parole, plus 20 years consecutive. Upon entering the Maryland State Penitentiary at 19 years old in 1989, I had the good fortune, I will say, to meet some good individuals that helped shape the direction of my life. These guys had 10 and 15 years in at the time when I entered the prison system in 1989. Some of the brothers out here now have been released. Yet, I spent 33 and a half years in prison, and I was just released last year. Some of those same guys that were beacons of light for me in 1989 that had already changed their life around because they had 10 or 15 years in at that time, they are still in prison now. And they have 40, 45, 50 years in at this time now. And I'm here to support this bill because I believe that they deserve a second chance, because it was because of them that I became who I became in life. And I would like to say that everyone, I believe, deserves a second chance. And since being home over the last year, I have 3 jobs that I work now, and I'm a people's person. I work at University of Maryland Hospital. I work in Redeem Healthcare and a drug recovery program. And I work at No Struggle, No Success, a reentry program that assists the transition of individuals that come home. And I believe Mr. Sicenti, the individual that he said was being released today, he's coming through our program. I arranged for him to have housing today upon his release. And that is what we are giving back to society and trying to, we can't change what happened at these times, but we can try to do better from the day on for ourselves and for those that we can impact, because it's needed. So that is basically the way I see it, because in closing, I just left Jessup Correctional Institution a year ago. And there's a whole building that no one knows. That's why I call them the forgotten. No one knows about. There's 388 individuals in that building, and we all work in the Maryland Correctional Enterprises and making license plates in the state of Maryland. And these guys are in their 70s and early 80s. They're in wheelchairs, being pushed by other elderly men in wheelchairs. No one knows about this. I'm speaking from ground zero.
Appreciate it. Thank you very much. I appreciate that. Thank you.
Thank
Good afternoon, Mr. Chair, members of the committee. Thank you so much for having us and for holding this hearing. My name is Keith Wallington. I'm with the Justice Policy Institute. And I'm actually here today representing the Lifers for Change. Some of you may have seen this, received this in the mail. This is from our partner inside MCIJ. The individuals in this book represent 1,207 years currently served. I meet with these guys on a regular, and every single time it's like going to visit a dark, cold nursing home with a bunch of just older family members. I feel safer in there with those guys than I do standing here talking to you guys. We can safely release these guys and other long sentence individuals. And behind me and sitting here is the proof that we can do it without not only without compromising public safety, but benefiting public safety. The UNGERS, and more recently, the Juvenile Restoration Act recipients were all long sentence individuals who have returned home and have extraordinarily low recidivism rates. The only difference between the UNGERS and the JRA recipients and those here are that the UNGERS and the JRA recipients were released on a unique mechanism that have not been afforded to the folks just like them that are still inside. The group today also clearly represents something pretty obvious. Maryland has a crisis of disproportionate representation of people of color in the legal system. particularly as long sentence population. If we care about this crisis, we're going to need more than one tool. As Stanley mentioned, we're going to need more than one tool to decarcerate. It wasn't a singular policy that got us here, and no singular policy will move us forward. So if we care about this crisis, and we should, then we need multiple tools in the toolbox for release in SB 389. Thank you.
I already been up here, y'all know who I am. And I just wanted to say, the bill yesterday, the 123 bill, and this bill is similar. You know, but I also believe that a person shouldn't wait till he's 60, because you have some people like Mr. Stephen Carr. He ain't 60. He didn't change his life. He became a better person, and he out here doing remarkable things in the community. And these are the type of men and women that we need out here. We've been through it. We know what they're going through, and we are best equipped to deal with these young kids out here nowadays, because we experienced the same thing they're going through. I was 17. I was one of these guys in Baltimore, robbing people, stealing people, breaking into people's cars, stealing cars. And at 17, I got a life sentence for first-degree murder. So the things that they doing, the things that they going through, I done been through. So who best to talk to these kids than somebody that they can relate to, somebody they can see themselves in? Thank you.
Hello, my name's Larry Owens. Did 42, 11 months, 6 days. It's not much to say, they've said it all. I'm just saying, like, I'm looking at it, you don't have to be 60 to turn your life around. Anybody who done any time, say 20 years, 15 years, they begin to think, you know? And like, I was young, I went in at 20. And by the time I had 15 years in, I began to change my way of thinking, of not looking at getting things my way. You know? That's where I changed the way to get a job, learn how to, you know, I had about, what, maybe 6 trades under my belt. I can sew, I'm wood carving, I've assemble furniture. It doesn't make a difference, you know. I've done it all, and you try to learn to, you know, make up for what the things I've done. You know, I'm not saying you know, I was innocent, which I wasn't. You know, but I'm saying once a person does a lot of time, he gets time to think. He wants to change his life. No kid wants to go in at 20, and after 20 years, he's not going to try to change. He wants to change his life around, you know. And y'all talking about 60. You might well say we're dead. We're walking dead. What about the kids that go in there at, like you say, 17 years? They did 20 years. 40. That's 37 years. That's a lot of time to think, to change yourself. You change your life around, you know, because you lose a lot. I lost a lot. My son, you know, and it give me time, you know, say, these are things that you miss, it hurts, you know, which I don't know if y'all understand what I'm trying to say.
We do, yeah. Appreciate it. Thank you for coming down.
Thank you.
All right. Is anyone, I don't know who else is here. Who else is here to testify in favor of this bill? All right, come on up. Yes, sir.
My name is Johnny Reynolds, and I'm in support of 389. Today, I've been home 11 months and 17 days after serving 37 years, 4 months and 6 days, right? I am a positive example of what second chance does, right? I'm working, right? And I have a car, I have my own place now. You know, I don't have no medical insurance. They won't give me none because they say I don't have enough points to to be awarded of Medicare, right? And I think that a lot of men, not just 60, but as some of my fellow brothers said, it doesn't take much to change your life around to see a difference that you want to make within yourself and maybe the life of others, right? Growing, part of my jobs inside was I was a barber. Then after that, I became an observation aide. This observation aides are guys that, or people that go down and help guide people that are trying to commit suicide or going through a lot of mental issues, right? And I really, really feel that, that guys, men and women should be given a second chance, because just wasting away in prison, oh man, words can't explain how I actually feel, right? So I'm gonna give the floor to someone else.
Hello, my name is Gwen Levi. I'm 78 years old. I'll be 79 in a couple of months. But I spent time at the Maryland Correctional Institution for Women. I worked as an observation aide. But most importantly, I worked with seniors. Seniors who, some were wheelchair bound, some were as energetic and walked every day and had strength that they could do anything they wanted to do. They had been in there for 30, 40, some went into 17, a couple went into 15. They had completely transitioned. They had completely changed their lives, but yet they were still housed there. So you know what we did? We formed groups. We formed programs. We formed a group called Women of Wisdom that helped we didn't have wheelchair ramps. We didn't have wheelchair lifts. Many of us were in wheelchairs. Many of us were using canes. You know what we had to do? And they're still doing? Be carried downstairs when the wheelchair lift is broke to go and eat in the dining hall. Most of these women have talked to their victims. They've asked for mercy. They've talked to their victims. They've asked for absolution from their lords. And they've earned the right to come home and try to live a decent life and be able to help us with some of these young women. I heard a lot about the young men. We need mentors for our young women also. A lot of mothers are down in Jessup, suffering, staying there longer than what society, I think, would want them to be, because now they can come out and help with some of the issues that we're dealing with. Please, if there's any way we don't have to wait until we're 60 to let them out, let's do that. But if that's necessary to wait, let's pass this bill. But I urge you to look into a bill that would allow women who have done 20 years or more to come home and be a part of our society.
Good day, everyone. My name is Willie Hamilton, and I'm in support of SB 389 without amendments. I sit here before you today, a recipient of a bill that was created here, the JRA. I spent 30 years, 110 days, and I was incarcerated at the age of 16. And I had the honor of meeting some of these men who guided me into a place that I am today. Like Ms. Carter said about the indoctrination of some of our environments, I grew up in some of those places and thought that was the only life that I had to live until meeting some of these men. And I'm in support of this bill because I had the opportunity to be on these forgotten tiers with these older gentlemen who have served 20, 30, or 40 years or more, who can't fend for themselves anymore. So it's cost effective to release them. They're not a security risk to our environment. Then they have so much wisdom that they can offer. Just to give you an example, one of the elder men that I helped take care of, he told me to understand the magnitude of my offense, and not only understand it, but to make retribution for it. first with myself and then to society because I owe a debt. So the men behind you will tell you that when we talk about victims, we understand it, we shadow them, we wake up with them, we sleep with them. We go about our days trying to do what is correct because of them. And I don't say this a lot, but because of my victim, I'm here today. I don't know where I would have been 30 years ago if it was not for me being in that situation and meeting men like this. So there's so much that these men can offer, and it'd be so much cost effective. Thank you.
Second chance.
Come on now.
Here we go. Second chance. This is second chance. Bill 389, Bill 123 is about second chance. I want to be appreciative to the second chance that I received. I'm one of the youngest ones that came in. I came in at 15 because I made a bad decision. A purse was snatched. Instead of me going to help the lady, I went to help the man. And so I spent 28 years thinking about the mistake I made. Remorsefulness set in to a point that I cried to make sure that I had a chance through my lawyer to speak to the victim's sister and daughter. So today I am an advocate of reentry. I'm a mentor of reentry. I do substance abuse. I was using drugs before I went to prison. I used drugs during prison, and I use drugs now. I am 10 years clean for substance abuse because I know I had that second chance. This second chance means a lot to those who are 60, 50, and it didn't take me long to get rehabilitated to this place that I needed to be. It didn't take me long. So you say 60, you start at 60 and you work your way down. You will see that you'll get deeper into the 50s and the 40s, that whereas though you're gonna find people like us who will be able to go back into the prison and help those who need that second chance. Thank you.
Good afternoon, Mr. Chair and the members of the committee. My name is Louis Fields, and I live in the 40th District of Baltimore City. And much of my work involves trying to educate young African-American boys. And even on February the 11th, I have a church that's asked us to come in and speak to 45 boys who are between the age of 8 and 18. It's called Operation Timothy and Set the Captives Free. They asked me to come in on February 11th, Super Bowl day, and speak about public safety to these young boys. And I just came today to say, who else better could I take with me than some of these brothers right here? Because sometimes you need to hear from someone who did what you might think you might do sometime down the road. I believe what we have behind me today is a resource, assets that can help us reduce crime. Because sometimes young men, particularly young Black men, they grow up without having mentors like these. No father in the house, no uncles coming around. So sometimes when people become victims and then they look for someone to help them out of that victimization, you need someone who can take you by the hand. Say, I walk that path. That's not the way to go. Let's look at another opportunity for you to be a better young man. And purposes like myself, well, I haven't been to Jessup. I haven't been to any of these places these brothers have been. So I can't speak about that experience. But suppose I had one or two of them with me as I go throughout the city talking to young men about making the right choice. Don't throw your life away. In Baltimore, across the state, we're having such problems with juvenile crimes right now. We really need these brothers and sisters to come help us out. So on behalf of the friends and people that I work with throughout the state, we are in strong support of House Senate Bill 389 and Senate Bill 123. But I ask you as members of the committee, just think about who could better tell a story about why you don't want to go to the prison system than these fellas right here. Thank you very much.
Thank you very much. We'll now switch to two of our participants who are coming to us virtually. Annie Kirsch and then James Johnston. All right, and if you want to come off, hey, welcome back. You've got the floor. Go ahead.
It is good to see you. It's good to be here, and I'm sorry I can't be there with you in person. I wanted to talk about the cost, but it seems like you already know the millions of dollars that are being spent, about $1 million a person for the geriatrics who are being incarcerated, that are such a low safety risk that when I look at the numbers, I can't help but think that it might be a better investment of our resources to incarcerate random people off the street. These people are such low risk. But I also work for an organization called Prepare, where we employ 7 returning citizens, 3 of whom are juvenile releases. So I can talk to you about what it really looks like to have people who have served 30, 33, and almost 43 years in prison work with you every day, because I have 3 people. Our Prepare for Success program manager is a juvenile release. We have a reentry specialist and a parole advocate. They are covering every side of the system, reaching out and helping other people like them get themselves together, learn what to do inside the prison, learn how to better themselves there, and then come home and continue to better themselves and become successful when they return to the community. These are people who volunteer hours. These are people who insist on doing hard work, extra work to make sure that people are successful. They have a heart for service like I have not seen in other workers anywhere. So when I say you are paying millions of dollars to keep the solution away from the problem, that is exactly what you're doing. And so I ask for a favorable report on these bills. So these people who are 60 years old, who are low risk, can start coming home and fixing some of the critical problems that are facing us today. And I thank you for the opportunity to, and look forward to seeing you again. Thank you. To make sure that people are successful and have a heart for
you.